I think you heard the testimony from Mrs. Kinez regarding this photograph. What is depicted in this photograph?
That looks like the finished side of my basement.
Okay. And I think Mrs. Kinez testified that there's different shades of color shades on those tiles. When you lived there, did you notice variations in the color of the tiles that were in the basement?
No.
Okay. Did you ever replace any of those tiles?
Never.
Did you ever re-grout any of those tiles?
Never.
What would you expect to see if you had replaced or done any tile work there?
Well, let alone the grout would have a different shade automatically because you can't match the original with the replacement grout.
So if tiles were replaced, how would you know that?
Just based on the grout around the tiles, they would be a different shade from all the others.
Okay, let's have Exhibit 37. Is Exhibit 37, does that depict the same sort of area that we just looked at in Exhibit 29?
Yes.
Okay. Is that a carpet in the middle of the room there? Or what is that? Yeah.
My wife's decoration.
Okay. Did you have a throw rug or keep a rug there during the time you lived there?
When she moved in, yes. But prior, I had no rug there.
Oh, okay.
So for 5 years, there was a rug there.
Okay. All right. Let's have Exhibit 38, please. Is that the same tile? I'm sorry, what are we seeing in this particular exhibit?
That's the back of the finished room. That's where the table and our little bar would be, where we'd make drinks and hang out occasionally.
Okay. And is that the same tile floor?
Yes.
Did you ever replace or repair any tile in this part of the basement?
Never.
Okay. Now, I want to direct your attention to August 2nd of 2021. You can take that down, Alex. Thank you. When your house was up for sale, you heard Ms. Kinez describe a conversation that took place in your driveway between you and her.
I did.
Okay. Do you remember having a conversation with Mrs. Kinez?
I remember talking to her and her agent.
Okay. Was that the first time you met Mrs. Kinez?
The first and only time.
Okay. And what do you recall about that conversation?
I walked up the driveway because they were leaving. I had my son. He was hungry. She asked me a couple questions. I answered every question honestly to the best of my knowledge. I had no reason to lie because I already had an offer and someone was going to buy the house if she didn't.
Okay. What sort of questions was she asking, if you recall?
I believe she asked me about the park, the locations of schools. She asked me about water, and I said I didn't have any issues because I didn't have any issues. And I believe I told her how close the police department was and how they're 2 minutes away and how safe the city was.
What specifically do you recall her asking about the water issue?
I believe she asked if I ever had any water issues. And I said no.
What your response was?
No.
Okay.
No.
Did she elaborate on that question in any way or make it or indicate that her interest in the house was contingent upon the issue of water?
Not to my recollection.
Okay. And you said you had offers on the house at that time. Is that right?
Correct.
You
Correct.
had one, more than one?
More than one.
Okay. Can you recall what type of offers you had at that time?
I remember one was over asking price for cash.
Okay. Did you have any offers that involved the contingencies?
Lori would know better, but I believe so.
Okay. So at the time you had this discussion with Mrs. Kinez in the driveway, had she made an offer on the home?
No.
Do you know whether, at that point in time, were you aware as to whether she was going to make an offer on the home?
I had no idea what she was going to do.
Okay. All right. Thank you. However, you did receive an offer later that day from Mrs. Kinez?
I did.
Okay. Can you bring up Exhibit 1, please? Plaintiff's Exhibit 1, sorry. Okay. Nick, this is Plaintiff's Exhibit 1. Have you seen this document before?
I have.
What is this document?
This is our purchase agreement.
Okay. And who prepared it, if you know?
I believe her agent did.
Okay. And did this purchase agreement have any contingencies on it, connected with it?
I don't believe so.
Well, let's go look at the... Was Mrs. Kinez offered an option, any options to follow through with before closing on the contract?
Yeah, she was able to have a home inspection.
Okay. Is that what's depicted in this page of Exhibit 1?
Yes.
Okay. It says home inspection within 7 days of the agreement. Did I read that correctly?
Where are you at?
General home, the box is checked.
Oh, yes, sorry.
Okay. To your knowledge, did Mrs. Kinez have the house inspected?
Yes.
How do you know that?
I was told by my realtor.
Wait. How do you know that?
I was asked to...
No. What did you do? Did you do anything to assist in the inspection?
I left the house.
Okay. For how long? Do you recall?
A couple hours.
Okay. Have you ever seen a report from that inspection?
No.
Okay. After the inspection, what happened?
I was informed that we were all good to go and she was going to take the house as is.
Did you ever see this document, the amendment to the agreement?
Yes.
Okay. And what's your understanding is the effect of this document, the amendment to the sales agreement?
That she's taken it as is, no changes.
Okay. Were you ever asked to adjust the purchase price?
No.
Were you ever asked to perform any repair or modification work at the property?
No.
Okay. Now, I want to return to the subject matter of water in the backyard. If we could bring up Exhibit 11, please. Plaintiff's Exhibit 11. I'm sorry, Alex. I promised to do better. Okay. I believe I believe, Nick, you heard testimony yesterday about Exhibit 11. Can you tell what's depicted in Exhibit 11?
That is not my backyard.
How do you know that?
I'll explain several reasons. Right here, this is a white garage. I had a tan or clay colored garage. In the back, I had glass block window. There's no glass block window. Third, I had a 6-foot fence here, just a chain link here. So on both sides, I had privacy fences, so you couldn't see your neighbor's yard. I was never able to see Marissa's yard. Therefore, I've never seen whatever this is, somebody's garden box. That's my first time seeing when I saw that photo. Okay. So I can clearly say this is not my backyard.
Okay. And do you know whose backyard it is?
I'm guessing Marissa's.
Okay. Do you know who took that photograph?
I have no idea.
Do you know when that photograph was taken?
I have no idea.
Okay. Then, let's take a look at Exhibit 12, Plaintiff's Exhibit 12, Alex. Can you see what's depicted in Plaintiff's Exhibit 12, Nick?
Yes.
Now, describe what you're seeing here.
That looks like, I could tell this is my yard because of the fence, but that looks like we had a lot of snow, and it was either a quick defrost or rain where things were melting quickly.
Did you experience difficulty in snow melting and failing to drain while you were living there?
Well, yeah, you can't control how fast snow melts.
Okay, but I mean, did it develop into a problem for you?
No, I never had water problems in the backyard.
Did the snow melting create a chronic drainage problem in your backyard while you lived there?
No.
Okay. Let's look at Exhibits 15. Okay. So what is depicted in Exhibit 15 as far as you can tell?
As far as I can tell, that's a yard with water, but I can't tell you that's mine because there's no characteristics where I can identify that being my yard.
Okay. And do you know when this photograph was taken?
I have no idea.
Okay, let's look at Exhibit 16. Now, you heard testimony that this is Mrs. Kinez's son standing in this water. You heard that testimony?
Yes.
And you saw the video?
Yes.
It appears to me, or does it appear to you, that the photograph and the video are the same occurrence?
Yes.
Same day?
Yes.
Okay. Do you know whether or not, or can you say whether or not the photo and the video depicted your backyard?
Yeah, the video was my backyard, and the way I could tell is because both fences on both sides.
Okay. So, have you seen any other video, any other photos other than the photos in Exhibit 11, 12, and 15 that show your backyard with ponding water?
No.
Okay. So, we know that 15 and the video were taken on the same day. Is that correct? As far as you can tell?
As far as I know, yes.
Okay. Exhibit 12, again, was snow melting.
Yeah, that's what it looked like.
And Exhibit 11 was Marissa's house, to the best of your knowledge.
To the best of my knowledge, it wasn't mine.
Okay. So we essentially have one day of photographs showing this condition at your property. Is that right?
Objection.
Well, let me
Sustained.
re-ask the question. How many photographs have you been shown in this trial, or how many days of occurrence, or how many occurrences of ponding water have you been shown in this trial?
Whatever they have here, the 4, 5.
No, how many
Oh.
occurrences?
Objection.
Approach.
Nick, Exhibit 16, I think, is, and the video were, appeared to you, you said, were they taken on the same day?
It appears so.
Okay. And Exhibit 12, can we have Exhibit 12? Tell me again what Exhibit 12 depicts.
Snow melting in the backyard.
Okay, and Exhibit 11, can you show me Exhibit 11? And what does Exhibit 11 show?
Somebody else's yard with water.
All right, thank you. Have you seen any photos of these areas 2 or 3 hours later?
No.
Okay. So we don't know what condition, we don't know.
Objection.
Or,
Sustained.
Let me re-ask the question. Do we know what the condition of these areas was 2 or 3 hours later?
No.
Okay. I want to talk about the text message exchange that you had with Mrs. White on August 7th of 2019. Do you remember that day?
No.
Okay. Were you ever made aware of any communication exchange between yourself or between Mrs. White and your wife?
No.
Okay. Did your wife ever describe to you any water damage in the house that day?
No.
Did you ever observe any water entering your house that day?
No.
Okay. Was there any damage caused to your house because of water that day?
No.
Do you have a recollection of that day, any storming that day?
No.
Okay.
I was probably working.
Okay. Did Mrs. White accurately describe the relationship that you had with her?
Not at all.
Okay. Can you describe your relationship with Mrs. White while you lived there?
We chatted every now and then in the yard when she would be peeking over the fence that was higher than her. Unannounced, she would just walk in my yard and want to talk, and I would have to go in my house because I was annoyed. At no point did she help me pick my outfit out for my wife's date. I never went to a cookout there. And the only time I ever complained about her kids was when everyone was slamming the door at midnight and the houses are so close it would echo my kid's room.
All right. Did there come a time when your relationship with Mrs. White changed?
Yes,
When was that?
when I was sent inappropriate things.
Okay. What did you do with whatever you were sent?
They were deleted once my wife came into the picture, but I showed a friend just in case something ever came back to protect myself, to say, this was sent to me, I never sent anything to her.
Why did you do that?
Just to protect myself and my career.
Okay. All right. Now, you understand the claims that are being made against you in this case?
Yes.
And you understand you're being accused of fraud?
Yes.
Nick, did you ever intentionally conceal a material fact relating to the sale of your home from Mrs. Kinez?
No.
Did you ever make any false statements regarding the condition of the property in connection with the sale?
No.
Did you ever have the specific intent to mislead Mrs. Kinez into relying on any false representations?
No.
Did you at the time of Mrs. Kinez's offer on the house, did you have other offers?
Yes.
Okay. Do these allegations in any way, would they impact your profession as a police officer?
Objection.
Sustained.
Can I approach?
Sure.
Nick, after you sold the house, you moved. Where did you move?
The Concord.
Okay. And is it where you're living today?
Correct.
Okay. Did you make any repairs or anything, modifications to the house that you live in now?
We redid the kitchen and had a room painted.
Okay. And did you have leftover painting cans?
We did.
And what did you do with those cans?
Put them in the basement in case I have to touch them up.
Okay. When you moved into that house, did you have it inspected?
I did.
Okay. Did the prior owners leave anything at the house?
They left paint for me in case I have to touch up in the bedroom or anything else.
Okay. Thanks. That's all I have for you.
Sternberg, cross-examination.
Thank you, Your Honor. Mr. Zubnik, when you did your drive, that was in 2018?
2018, 2019.
Well, what is your best recollection?
2019?
Okay, and when did you do your drive in 2019?
It would have been in July.
Okay, and you've testified when you did your drive, you put in a drain to catch the water from the drive in front of the garage, correct?
Correct, the catch basin.
Catch basin. And you testified you tied that catch basin into the downspout. Is that correct?
Correct.
Okay, which downspout did you tie it into?
So the garage had a back downspout and a front downspout. We wired off the catch basin to that downspout. Then the catch basin from the garage was connected to it, and then we ran all those pipes to the back downspout that already had existed. So we took pipes out and put the same pipes back.
When you say the same downspout that already existed, was that on the garage or on the house?
On the house.
Okay, so that water that was being collected from the driveway by the catch basin was all directed to the house, correct?
Correct.
Okay. And was that inspected by the city?
It was.
And it was approved by the city, wasn't it?
It was.
Are you familiar with the city of Willowitz code regarding downspouts?
I don't know the codes offhand.
Okay, but you knew it was okay to attach it to the downspout?
Yeah.
Okay. Now, when Ms. Knez met you in the driveway, her uncle was with her too, correct?
What'd you say?
When Ms. Knez met you in the driveway,
But then I knew what you said to that.
her uncle was present also.
That's what I missed. Okay.
I remember her and the agent. He could have been. I really wasn't paying attention.
Okay. And in a legal proceedings in this matter, Ms. Knez had detailed in an affidavit what she had spoken to you about. Do you recall that?
Yeah.
Okay. And do you recall your affidavit in opposition to her affidavit?
I mean, I'd have to see it. It's been 2 years since I did it.
Okay.
For the record, we're gonna mark it, just so it's, so there's something to reference. We have something, Dave, Mary's got it. All right, where are we at? I think we would, so this would be 41.
Yep.
Mr. Zebnik, I'm going to be handing you what's been marked as plaintiff exhibit 41. Take a moment to look over it.
All right.
Calling your attention to paragraph 6. Can you read that for us?
I recall the conversations to which Ms. Knez averred in her affidavit of March 18th, 2024, and maintain that my statements are accurate and honest to the best of my knowledge.
Do you recall the statements that were in her affidavit?
I mean, I'd have to see her affidavit.
Number 42.
Sternberg, can I see what you're?
Oh, I'm sorry.
Are these all the exhibits today?
Yeah. Yeah, I don't want to obscure not to attach them because you can collect about.
Why would you do that?
Yeah, you know, it's been marked as plain exhibit 42. Let me ask you to review that.
You want me to read the whole thing or just the first paragraph?
No, review the whole affidavit.
Just yourself.
All right.
Why don't you read paragraph 3 of your affidavit?
Affiant questioned Nicholas Zevnik concerning any water problems, and he responded that the property did not have any water, sewer, or drainage problems. This conversation was witnessed by Jeff Hathey, Sebastian Canez, and Roland Hudek.
You still have your affidavit?
No.
Yeah, make sure you leave that up here. We'll make a copy of it if you need it, Dave.
Yeah. Paragraph 6 of your affidavit.
I recall the conversations to which Ms. Canez averred in her affiant of March 18, 2024, and maintain that my statements were accurate and honest to the best of my knowledge.
So she did ask you those specific questions about water problems on the property, is that correct?
If she says, then she must have, and I answered to the best of my knowledge and truthful.
Well, before you didn't seem to recall the questions, yet in your affidavit, you specifically replied to what she had said, saying, yes, you recall the conversation. Was your memory better back when you did that affidavit than in court today?
Objection. Can we approach?
Sure.
When you put in your new driveway, did you have an engineer look on how, advise you on how to connect the downspouts?
Well, I didn't put it in. I had somebody do it and put a permit. I just assisted.
Okay. And how did you assist?
I picked up concrete, I drove the dump trucks, and I helped rake the cement.
Okay. And was any engineer involved in designing how you were to attach your catch basin to the storm water?
Not to my knowledge.
Okay. Now, you heard testimony regarding the number of times the backyard has water, is that correct?
Yes.
Okay. Access, Your Honor?
No, I'm sorry.
Now, Plans Exhibit 12, that's your backyard, correct?
Yes, because I could see the fence.
Okay. And your testimony is that that was from a snow melt, correct?
Looks like a quick snow melt, yeah.
Well, how can you tell if it's a quick snow melt?
You got all the snow right here just melting away slowly.
And where's it melting away quickly?
Probably all here.
Okay. And while you lived in the house from 2011 until moving out in September of 2021, did you ever have snow in the backyard?
Yeah.
Okay. Did you ever have large accumulations of snow?
Oh, yeah.
Okay. And when that snow melted, did you have ponding in the backyard?
Not like that.
Not like that.
Nope.
What type of ponding did you have?
I don't know. I never took photos.
Well, I understand you didn't take photos, so you can't show us, but certainly you have some type of memory as to how it ponded.
No. I never looked like that right there.
Okay. Now, your testimony was that you couldn't tell where that picture was in your backyard or not, correct?
Correct.
You have a chain link fence in your backyard, is that correct?
I do.
Okay. That picture taken on a different day than the picture in Exhibit 12?
I don't know when it was taken.
Okay, well, you've heard testimony that it was taken on a different day. Do you dispute that?
I would take her word.
Okay. Now, is that the backyard of your house?
I have to wait to see the fence.
The grass.
Right there?
It's squishy.
Yes. That's inside my fence, my yard, so yes.
Okay. Did you have ponding like that in your backyard?
No.
That appears to be a different day than the earlier picture with the snow, doesn't it?
Yeah.
Okay.
Or it could have been later, depending on the weather.
Can you explain why also the property would have that type of ponding?
I can't explain that.
Okay. The testimony is that those were taken fall of 21 and winter of 22. That's what, about 3 months after you moved?
I moved in September, so yeah.
Okay. But you never had any ponding?
No, not like that.
Well, that's why I was trying to ask you before. What type of ponding did you have?
If you go back to the picture, I could show you.
Which one do you want me to go back to? Do you want me to run them up so you can point out?
Anyone.
Okay.
Pick another one. It's easier for me to... Closer to the fence area. So right along here, there's a dip. and I would have a little water right here. And how do I know? Because during the summer, the spring and the fall, I was able to cut my grass all the time and never have to wait for the water. So water would pond along this fence, like right here, but never right here for me.
It doesn't appear to be ponding along the fence, does it?
Well, that's not my yard.
In your yard, do you see where there's grass at the edge of the pond?
I do.
That grass is on your side of the fence, isn't it?
It is.
Okay. So it's not ponding right along the fence, is it?
I didn't own the yard at that time.
Okay. Well, was the yard... You didn't change the elevation of the yard along the fence, did you?
I never touched the yard.
Okay. Do you doubt that the backyard ponds in the winter of 21, not winter of 21, fall of 21, winter of 22?
Seeing these? Yeah, that's a pond there.
Okay, so you don't doubt that it did?
For her, yes, I see that it did.
Okay. You only had ponding along the fence, is that correct?
Correct.
Did you ever tell Ms. Knez about it?
No, because it wasn't a water issue. It wasn't a water problem.
Okay. Did she ask you about the backyard and water?
Yeah,
Okay. But you didn't think that was a significant issue to tell her?
if I would tell her about the puddles along the fence, then I should have probably told her about the puddles next to the curb.
Okay. Okay. Now, you said, let's go back to it. Showing what's been marked as Plaintiff Exhibit 36, which is a text conversation on August 7th of 2019, which is, if I understood your testimony correctly, after you put in the new catch basin when you redid the driveway?
That would have been correct.
Okay. If I understood your testimony, your wife never told you about this conversation, is that correct?
Nope.
Did your wife ever tell you about any incidences that happened at home?
You'd have to ask her.
No, I'm asking you if she ever called you about any incidents that happened at home.
No,
Never called you?
no, because I took care of the house.
Okay, well, did any of your appliances ever break while your wife was using them?
Nope.
No? So your wife never called you with anything that was going on in the house?
No,
Because you took care of the house?
I was home every night.
Okay. Okay. Now, you stated you hired Carlos and Son to do the painting?
Correct.
Okay. Carlos and Son isn't on your witness list, is it?
No.
Okay. So we won't have Carlos and Son here to tell us what they painted and what they didn't paint. Is that correct?
Correct.
Okay. When you were shown
Pause for a second. All right.
Handing you has been marked as Defendant's Exhibit A. Are you familiar with those?
That's my house.
Okay. Did you hear testimony that was the listing pictures?
Yes.
Okay. Is that how you recall the listing pictures, Will?
To be honest, I never looked at them.
Well, does that picture fairly and accurately depict what your house looked like in August of 2021?
Yes.
You had these discolorations in the lawn?
That's from the photo, probably the camera.
Okay. So it really doesn't accurately depict, does it?
If you're gonna look at that, then no.
Is that a better picture?
Yes.
And there were a number of pictures in the listing, is that correct?
Yeah.
Is that what the kitchen looked like?
Yep.
Living room, dining room,
Yes.
family room?
Living room, yeah.
What rooms are those?
Living room, bedroom that was painted, bedroom that was painted.
Okay.
This is still my bedroom and my wife's that was painted. This was my son's room.
What color did you paint your bedroom?
I don't know, you'd have to ask my wife.
Same color as your son's room?
I don't know. My son's room wasn't painted.
Okay. Let's go to the basement. Is that an accurate description of what the room looked like?
It is.
And that was the other side of the room? Of the dining, like,
The finished, yes.
now you said on the far end, in that hutch or bookcase, was your bar setup, is that correct?
Correct.
Okay. Yet you stated you didn't use the basement, is that correct?
Not all the time. We occasionally used it.
Well, frequency-wise, how occasionally did you use it?
We'd go down, make a drink, go up, go sit on the deck.
Okay. So you didn't entertain at all in the basement?
I believe I said we had one Christmas family party.
Okay. That reminds me, the realtor said you weren't family, is that correct?
Not by blood.
Okay. But your sister's married to her son?
Correct.
Okay. Now, you said that Mrs. White had mailed you or texted you some inappropriate pictures,
She did.
and you said you kept that until your wife came into the picture?
Yeah.
Why would you have kept it?
What single guy wouldn't keep a picture of a girl?
Okay. Were you present for any of the dye tests?
Yeah, I was there.
Okay. Did eye test tell whether or not there's water intrusion in a basement?
No, just tells if the pipes leak to one another.
Right. Whether the storm leaks into the sanitary, correct?
Correct.
Okay. Do you have anything else you want me to ask? Nothing further, Your Honor.
Redirect examination.
Yes, thank you, Your Honor. Nick, when you had the driveway replaced at some point while you owned the house, right?
Correct.
And the original driveway, did that also have a drain?
It did.
And was that drain connected in a similar fashion to the drain that the new driveway was?
The same exact way.
Okay. Now, can you estimate the square footage of the back garage, of where the drain would be? The concrete square footage there?
All I know is we had 19 yards of concrete in the driveway.
Okay. Would the square footage, based on your observations, be greater than or less than the combined backyards of these four houses here?
I'd say less than.
Okay. And while you lived there, there was no while you lived in the house, there was no drainage from these backyards, your neighbors' backyards, into your drain tile. Is that correct?
Correct.
All right. You said you were present when the dye testing was done. Explain that. When was that?
That was done in August before I sold the house. 2 guys from the city came out. I believe they cameraed, and then they put dye in the pipes. They let it run, and then they took their measurements, said it passed, and I paid them, and they left.
Who did you have anybody there that you knew perform the test?
No, the pre-dye test was done by Donnie Slapnicker. He's a Willow cop, and then the city he did the pre-dye test. It passed. He called the city of Willock. They came and they confirmed that it passed.
What is a pre-dye test?
A pre-dye test is basically they put the dye in the pipe, and then if it leaks into the sanitary or the sanitary leaks in the storm, then the contractor has to dig it up and fix it prior to calling the city so they don't waste their time. So either if it leaks at the crossover, you have to dig by the house. If it leaks by the T, you have to dig the T up. If a downspout leaks, well, then you have to do a reroute, and you have to reroute all the pipes into the main.
When the dye test is done, as you observed it, can you at least tell whether or not the storm sewer is operational?
Oh, it was flowing good.
No, can you?
Oh, yes.
Did you observe during that test, whether the storm sewer was operational?
Yes.
Okay. Who did the pre-dye test?
It would have been Maximum Masonry by Donnie Slapnicker.
Okay, so I thought you said he was a Willoughby cop.
Willowick
cop.
Right.
Okay.
Well, he also owns his construction business on the side, him and his dad. Unique Masonry Maximum. They do concrete work, waterproofing, they do block, they build houses. So on the side, he owns his business, but he's a full-time Willock police officer and dare officer.
Okay, thank you. Nothing further.
Recross as to the redirect.
Yes. Thank you, Your Honor. Can I have access, Your Honor? Looking at Plaintiff's Exhibit 15, do you see any water coming from the side of that picture, either side?
I mean, I can't see this whole side, but I mean, if you blow it up, it's hard for me. I don't have a screen here.
Do you see any water coming from the side?
What side are you talking about?
Either the left side or the right side.
I mean, there's water across the whole photo.
Okay?
Come through the grass, because it's just as squishy. Please. Because it's just as squishy.
There's water to the left, isn't there?
Yes.
And that never occurred while you lived there, correct?
This?
Yeah.
No.
Okay. Did you ever have water behind your garage?
Nope.
So those were all new phenomena.
Must have been.
And you have no idea why that occurred after you moved out.
Correct.
Nothing further.
Nothing further on.
You don't get 3 shots.
Oh.
Give me opportunity.
Thank you.
Thank you. All right, Mr. Fogarty, you may come in.
Yes, can I check to see if he's outside?
This is your expert?
There's one more fact witness before the
Oh,
expert.
you can go out in the bailiff.
Okay.
Or she, go out, you can go out with her.
Okay.
He's the other one. Esteemed retired cop.
No, that's his father.
The good old boys club again. It's true. They're all connected. It's like we all have each other's backs.
Mm-hmm.
Absolutely. Except the line of blue.
You can come out up here, sir. Up the ramp. Good, are you? Stop. Stand, raise your right hand. You swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth.
I did.
Whenever you're ready, Mr. Fogarty.
Thank you, Your Honor. Sir, can you state your full name for the record, please?
My name is Donald Slapnicker Jr.
Okay, and Mr. Slapnicker, what is your occupation?
I am a full-time police officer, and I also have a construction company
Who are you a police officer with?
with the city of Willowick.
And how long have you been a police officer for the city of Willowick?
13 years.
Okay. And you said you also operate a business?
Yes.
What's the name of that business?
Maximum Masonry.
And what does that business do?
Anywhere from sewers, concrete, and masonry work.
Okay. And did you ever perform any work or testing or any consulting work for property owned by Mr. Nick Zevnik?
Yes,
Okay. You know Mr. Zevnik?
I do.
Okay. And who is Mr. Zevnik?
He's a close friend of mine.
Okay. And he is also a police officer?
Correct.
Is that how the two of you met?
We've known each other since high school.
Okay. So what work or consulting did you do for the property that, and by the way, we're talking about the property located at 30208 Oakdale Road?
Okay.
Is that the work, is that the
Yes.
location of where you did your work?
Yes.
Okay. And describe for the jury exactly what work or consulting you did.
I helped Nick put a driveway in,
Okay.
and I did his pre-dye test for his point of sale.
Okay. we heard a little bit about what a pre-dye test is, but can you specifically describe to the jury what it is and what its purpose is?
Well, for the city of Willowick, you have to get a permit to do the pre-dye test, which you have to raise the tees and check the tees at the street.
Okay,
You put water in the farthest storm drain,
right,
run water for 15 minutes, and see if it comes into the sanitary tee.
okay. That's the purpose of the test, to see if the sanitary and storm sewer are,
Flowing, yes. And as long as if the dye doesn't go into the sanitary, I call the city and they come out and do their dye test.
okay, so you test it before the city tests it?
Correct.
Because what happens if your pre-test fails?
It would need to be replaced somewhere. You'd have to get a camera, scope it out, and see where you have a break.
All right, so what was the results of your pre-dye test?
It passed. I didn't see anything in the sanitary, so I called the city and he got his dye test.
While you're observing this, are you able to observe whether the storm sewer is operational during that time?
Well, you run water for 15 minutes from the farthest drain, and it flows.
Okay.
And you put dye in it, and it's like a bright green.
Okay, so when you performed your pre-dye test, you were able to observe that, at least on that day, that the storm sewer at the property was operational?
Correct.
Okay, thank you, that's all I have.
Cross-examination as to, cross-examination.
Mr. Slapnicker, purpose of the dye test is to make sure the storm water doesn't penetrate into the sanitary, is that correct?
That's correct.
Okay. Doesn't tell you whether or not the basement has problems with water backing up in it, does it?
It does not.
Now, you put the water in by running a hose through the furthest downspout?
Correct.
Which downspout did you use in this case?
I don't recall that.
Okay. You did the driveway?
Yes.
Okay. Are you a licensed?
I am registered with the city of Willowick, correct.
Okay. Now, it's my understanding you tied in the downspouts and the catch basin to the downspouts of the garage and the catch basin to the downspout of the house. Is that correct?
That's correct.
Which one did you tie it into?
I believe I did it the way it was. So we tore out the old clay tile. I think it was the one on the driveway side corner, and we ran new pipe from the driveway drain to where it was tied in.
Okay. Now, you don't use porous cement, do you?
Excuse me?
This driveway you put in, does it have porous cement?
I don't understand your question.
Porous cement is cement that absorbs water, allows water to pass through to the ground.
I believe all concrete does that. Unless you seal it.
Was this driveway sealed?
Not that I know of.
So there should not, if all cement is porous and allows it to go into the ground, why would you ever seal a driveway?
People choose to do that for salt and other reasons.
Okay. Okay. You would agree, though, the ground absorbs water quicker than cement, true?
What's that?
Ground absorbs water quicker than cement.
Well, of course.
Okay. Nothing further.
Redirect examination.
Yes, Your Honor. Mr. Slapnicker, Mr. Schoenberg asked you about water in the basement. Have you ever been in this home?
Yes.
Have you ever been in the basement?
Once or twice, maybe.
Did you ever observe any evidence of water intrusion in that basement?
No.
Did you ever smell a mildewy smell?
No.
Did Nick ever indicate to you that he had problems in the basement with water?
No.
Did he ever indicate that he had water problems, drainage problems in the backyard?
Not that in my knowledge.
Did you ever observe any ponding or water failing to drain from Nick's backyard?
I mean, I've been over there for a couple summer parties and never observed anything other than that. I can't testify to anything else.
Thank you.
Recross examination.
Mr. Slapnicker, have you ever been over there after a heavy rain?
Not that I know of.
Okay. Nothing further.
All right, you may step down. Thank you.
Thank you.
All right, you may call your next witness.
Your Honor, we call Christopher Courtney,
Christopher Courtney.
I'm sorry. This is you know what? I was gonna say,
Come out here.
we could step in at this point.
It's okay.
Yeah.
Good morning. How are
Sit
you?
that down for 1 second. You raise your right hand. You swear affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth.
I do.
That's it.
Thank you.
Your Honor, can we have access?
You can.
Thank you.
Good morning, Mr. Courtney.
Good morning.
Can you state your full name, introduce yourself to the jury,
Christopher Leland Courtney.
and what is your professional address?
700 Beta Drive, Suite 200, Mayfield Village, 44143.
And what is your occupation, sir?
I am a civil engineer and land surveyor.
Okay. Can you describe your education to the jury, please?
Sure. I attended high school at Richmond Heights, so born and raised on the east side. Attended university at the University of Akron, graduated in 1990 with a Bachelor's of Science in Civil Engineering, and then have attended and taught numerous seminar professional development opportunities since then.
Are you a licensed engineer?
I am. I'm a licensed engineer in the state of Ohio. I'm a licensed surveyor in the state of Ohio. And then I also have 2 nationwide certifications. I'm a certified professional in stormwater quality and a certified professional in sediment and erosion control.
Okay. So do you have you're an engineer, but you have a subspecialty in water?
Yes, my specialties are really municipal engineering, so municipal infrastructure, that and private land development, anything related to public utilities, public rights-of-way, easement, stormwater, water lines, sewers, sanitary sewer service facilities.
Do you have, do you do any municipal work in the area?
I do. I'm currently the engineer for the village of Gates Mills, and I am the assistant engineer in the cities of Kirtland and Chardon, where we take care of any municipal infrastructure needs throughout the community, either reviewing those plans if somebody else is doing the work, or we prepare the plans and administer all the construction for any municipally sponsored projects.
Are you a member of any professional organizations?
I am. I'm past president of the Municipal Engineers Association in Northeast Ohio, Professional Land Surveyors of Ohio, International Erosion Control Association, former member of the Entrepreneurs Organization. It was for an under 50-year-old business owner group, but I've since aged out of that group.
Oh, okay. In your professional career, have you been involved in drafting any codes or regulations that relate to drainage for municipalities or any other governmental entity?
I have. Back in the mid-'90s, actually, I was on the committee that wrote what would become the pretty readily accepted template for stormwater management ordinances in Northeast Ohio. And in the village of Gates Mills, I've drafted and council has adopted ordinance for sediment erosion control, long-term stormwater management, how to handle construction sites during construction, along with ordinances as it relates to illegal connections to storm and sanitary sewers in a municipality. And then I also was on a board with the Cuyahoga County Board of Health that drafted what became the statewide standard for how to investigate and correct illicit discharges into storm sewers.
Okay, thank you. Have you ever testified as an expert witness in a litigated matter?
I have. I've served as an expert probably a dozen times.
Okay, thank you. When were you first contacted regarding the case involving Mrs. Canez?
I think it was December of 2023, maybe very early very early January of 2024.
And what were you asked to consult about?
I was asked to investigate a home that had a potential water problem in the basement as it related to some issues with a residential disclosure form and not disclosing potential ongoing water problems that had existed in a basement.
What was Mrs. Kinez claiming as far as you became aware?
From my understanding and reading the complaint, that there was not a disclosure about standing water in the backyard, along with the fact that during heavy rain events that water would enter the house around the perimeter or right through that joint that's right at the basement floor and the basement wall.
Okay. What documents were you provided to review?
Okay, for me to refer to my report?
Sure.
Okay.
Have a copy of the report, Mr. Sternberg?
Yes.
I was asked to, generally what I do when I'm asked to be engaged in a report like this, I'll ask for as many documents as I can be provided because I never know when I may find something that's going to be relevant to what I'm going to be reviewing. But I reviewed the amended complaint dated January 24th of 2023, the answer to that complaint by the defendant, responses to plaintiff's interrogatories dated 9/28/23. There was a report from ER Concrete that was issued as it related to issues in the basement. I then also, along with the information that I'm provided, I go out and I look for information that I know is going to be readily accessible to me. So I looked at Lake County Geographical Information system that they have, which provides various mapping, aerial photographs, topography, some drainage elements, some public utilities. So I used that as a resource. There was a mold inspection report, permits that have been pulled for that for 30208 Oakdale from January of 2011 all the way through December of 2023. There was the purchase agreement between Petrozak and Zevnik dated 2011, 8/9/2011. Purchase agreement between Zevnik and Kinez dated 8/2/2021. Loss history of the Zevnik homeowner insurance policy between 2011 and 2021. Loss history for Pietrozak between 83 and 2003 for their ownership of the house. And then various correspondence regarding water issues with the various attorneys and principals. Sewer records provided by the city of Willowick as of 5/2/2022. Photos and videos from various states that were provided historically. I then conducted a site visit and took my own site photographs, looked at the site, and then there was an affidavit from Lori Pietrozak dated 1/17/2024. So there was a pretty comprehensive list of documents that I reviewed, either that were provided to me or ones that I found on my own in the course of investigating the matter.
Do you believe you were provided sufficient information to support the conclusions that you make in your report?
Definitely.
Okay. And were the conclusions in your report made to a reasonable degree of engineering certainty?
Yes, they were.
Okay. I'm going to ask that all your opinions today, as you testified to the jury, are made to a reasonable degree of engineering certainty at all times. Do cases or claims involving a homeowner not accurately disclosing water issues related to a house?
Not related specifically to a residential disclosure form, but in my capacity as a city engineer and a village engineer, I'm routinely contacted by residents that have water problems in their basement. And one of the hats that I wear in my capacity as a municipal engineer is I'm kind of the first line of asking questions for those residents, so they'll either contact me directly or the building department or the service department, and then I'll go out to their house and I'll obtain as many facts as I can. I'll look through the resources that I have, and then I'll try to counsel them on what is going on with their basement water problem and how they might go about fixing that. or if I think they may need to hire some other type of expert, sewer cleaning and televising, Roto-Rooter, somebody along those lines, in order to do some additional work in order to help provide more pieces to the puzzle.
Are there ways in your profession that you can determine whether or not there have been persistent water problems in a particular resident over long periods of time?
There are. I found that historically, if I walk into a basement that has had ongoing, long-term water problems, there's going to be some key things that I'll notice. Concrete block or concrete, which most house foundations are fashioned of, will typically, in the presence of long-term moisture, effloresce. You may have seen that in your own basement, where you kind of get that white, crusty salt on the basement wall. That is the moisture driving the salts out of the concrete or the concrete block that's used for a basement floor. So many times in presence of water long-term, you'll get that can occur on a painted wall if the paint is not waterproofing paint, occur on block, occur on concrete. Typically, there's going to be there may be some discoloration, some water markings that are noticeable on the wall. So there may be some other physical elements that I can see. Also, the thing that is primary in my mind in a basement that has perpetual water issues is going to be that damp, musty smell that you get in a below ground room that's got an ongoing water problem. It's going to be that damp, musty smell.
Is there any historical data that you can refer to in also determining whether there's pre-existing water problems?
Yes, typically there's going to be, if there's been an ongoing water problem, depending on the type of water problem, there's going to be some record at the city. The resident may have called the city to either clean out a sanitary or a storm lateral, so that would be the sewer pipes between the street and the house. There may be records if there's been any sort of a blockage of the main. The city sewer department, service department, county may have a record of that as it relates to any sewer issues that were experienced in the area. There may be, if there's been a house that's had ongoing substantial water problems, a good source of information is the loss history through their insurance company, because if they've had sewer backup, if they've had perpetual damage in the basement, it would be unusual not to have any insurance claims as it relates to water problems below grade.
Sticking to the historical information that you talked about just now, during your investigation of Ms. Kinez's complaints, were you able to determine what the historical information was regarding whether or not this property had long-term ongoing water problems?
Yes, I extracted enough sewer information from the city to determine that there were point-of-sale sewer inspections that were done. Typically, what a community will do when they have a point-of-sale inspection is they'll do a pretty cursory test of the storm and sanitary connections to the house to make sure they're not cross-connected. So they want to make sure the sanitary is not connected to the storm sewer and you're putting a bunch of dirty water into the storm sewer. Or vice versa, they want to make sure the storm sewer is not connected to the sanitary sewer, so you're putting a lot of clean water into the sanitary sewer, which has a whole other set of problems that goes along with it. As a part of that, they don't typically camera the lines, but they test them enough to know that the lines are operable. Typically, they will set up a dye test at the house, and then they'll look at the storm and sanitary cleanouts in the front yard to make sure the dye is in the right pipe. And then they will also look at the next downstream manhole to make sure that as they're looking down to the water flowing through that manhole, they're going to have the dye that's going to be in the right sewer. So it's showing that operational connectivity between the house, the lateral, that's the pipe between the house and the street, and then the connection to the main. So it shows operational ability of that lateral.
So you saw evidence of those types of tests having been done at this property?
Yes, according to the city's records, the point-of-sale inspections were done. It passed the point-of-sale inspections, which shows that the storm sanitary laterals were operable and connected properly.
Did you observe, prior to Mrs. Kinez purchasing the property, did you observe any historical data, discover any historical data with the city about complaints or calls to the city about blockages?
I did not.
Okay.
Yeah. I also, talking about the additional information that was looked at, I did also look at the loss history for the property over the 20 years of ownership that Pietrozek had, and then the 10 years of ownership that's in question here. So that's 30 years, and there was no losses identified on the homeowner's policy as it relates to flooding or anything for that matter.
And getting to your observations, or the observations you can make yourself when being in a basement that you described earlier about the fluorescent and the smell and so forth. Did you go into the basement of Mrs. Knez's home?
I did.
Did you observe any of those items that you described to the jury that would give you some impression that there might be long-term water problems in the basement?
I did not.
No effervescence?
No, I did not note any efflorescence.
I'm sorry.
Yeah, no, that's all right.
Yeah.
And then also there was not that damp, musty smell in the basement that I would typically see with a perpetual long-term water problem. And everything appeared, I didn't notice any discoloration for watermarks, etc.
Okay. I note in your report you evaluated and reviewed a report prepared by an Ed Reed. Is that correct?
I did.
Okay. And what was your understanding as to who Ed Reed is and what he did at the property?
My understanding, he was a contractor that was hired by the property owner to do some sort of drainage improvement work on the property.
All right. Do you know what the nature of that drainage improvement work was?
My understanding was that there was some drainage work that was done in the backyard, so there was the installation of some drainage facilities around the back of the garage, and then near the middle of the back of the yard, and then some pipe work that was done in order to connect that into a downspout at the back corner of the house.
Okay. Did you have an opportunity to observe that drain when you were at the property?
I saw the drain, the kind of a gravel drain that's back behind the garage, and then there's also kind of what I would call a small traditional catch basin kind of in the center of the backyard near the back.
Okay. Did you have an opportunity to observe how that drain was installed in the property?
I did not see it during the construction because that occurred prior to my visit, but through looking through the Lake County Geographic Information System, they have historical photos in that program. So when I'm looking at that, I can kind of use the slider to slide back and look at prior historical photos, and it became very obvious how that drain was connected by looking at the dirt trenches that were dug through the backyard. So I was able to ascertain how that was done by looking at that information.
And how was the drain connected as you observed?
So looking kind of from the back of the property, the garage is over to the left and the house is up here. The drain in the middle of the backyard is here. There's then the drainage that comes over from the garage. They Y together, and then they run and they connect to the looks to be the downspout at the back corner of the house. As you're looking at the back of the house, would be the back right corner of the home.
Would you be able to identify what you just described to me by referring to this photograph?
I would. You can see the kind of light-colored Y in the backyard. Those are the trenches.
Okay.
And then they kind of go into the shadow over on the right-hand side, but then they connect to the downspout right at the back corner of the house, kind of just to the right of that hexagon.
So right here?
Yeah, right over in that
So
area.
the drain from the garage and the drain from the backyard turn into a Y and run this way to the house and are tied into the downspout?
The downspout, correct.
Okay. Can you describe what the drainage area would be for this particular yardage? I'm sorry, that particular yard drain that was installed?
So the way the drainage for this development works is this is an older neighborhood, so I would typically classify this kind of rear yard drainage as kind of poorly drained as people have done their landscaping and put lawns in and everything. But there is a swale that runs along the rear line like that goes generally from left to right, and then the yard for the subject property, that generally the elevation comes up slightly right at the fence line on the back, kind of separate that swale from the backyard drainage, and then the whole backyard drains from back to front
Okay.
on the subject property.
Okay. When the yard drain was installed, where would how much acreage or how much footage, or what would the drainage area, like what pieces of real estate would drain into that drain?
So the new drain as it's gone in. So right now, I would say what you can see on that photo, some of the rear yards of those properties that are towards the lower part of the picture, they drain towards that rear property line. And then also properties that are to the left as they drain down through that rear yard swale, kind of on. It's picking up, the new drain is picking up drainage out of the backyard of the subject property, and now because of its location, also picking up water out of from the properties behind the subject property.
Okay. And the drain pipe here, it's buried underground, correct?
It is.
Is it pitched a certain way?
It is pitched from the back of the property towards the house.
Okay, and does that permit gravity to
Yes.
direct the flow of the water?
Correct.
So am I correct that this yard drain is taking in water from adjacent properties and then sending it directly to the subject house?
That's correct.
Okay. And it's connected to the downspout, you said?
That is correct.
Is that an appropriate configuration for this type of drainage design?
In my world, no. I hesitate to do that at all times.
Okay. Why?
So the foundation drainage system for a house is meant to be somewhat of an isolated drainage system just for the foundation of your house. There are generally two pipes that go around the foundation of your house. There's one that is deeper, and it's right down at the bottom of the foundation wall, and it's got holes in it that face down, and that's what picks up all the drainage from around the foundation of your house and the stone that's around the foundation of your house. So that we're going to call that a foundation drain. That's what it's called. So that's the foundation drain for the house. So that drain itself is only meant to pick up the water that is either coming from the ground or may fall from the rain and drain against the foundation. It's going to run into that pipe. Then you also have your downspout loop. So if you've got downspouts on your house, that pipe's going to be maybe only about 3 or 4 feet deep. That's made out of solid pipe, and that picks up just the downspouts. And then what happens is those two pipes typically extend into the front yard, and then they come together into a 6-inch pipe that is your storm lateral that goes out and connects to the storm sewer. And that system, that 6-inch pipe, is meant to carry your downspouts and your foundation drains. And 6 inches is relatively small when it comes to storm sewer sizing. What happens when you start tying in yard drains and bringing other parts of yard drainage into that system, number one, you're inviting all that water right around the foundation of your house. So you've created, in this instance, a trench, the bottom of which is sloped, that runs from the backyard where there is known to be water ponding on the adjoining property that I saw, and then allowing that water direct access right to the foundation of your house. So even if all the pipes are working fine, you've increased the amount of water against the foundation of your house by a substantial amount. In my world, that's a bad idea. The other issue that it brings up is if there's ever any problem with the storm connection out in front of the house, where it becomes blocked or crushed, then there's a potential for that water to back up around the foundation of the house as all the water from the higher elevations, downspout, yard drains, volume of water tries to push through that system. So it can create potential future backups by virtue of by additional water and then any potential problems with the pipe.
You were aware that there was a permit pulled from the city of Willowick for the installation of this yard drain, is that
Yeah,
right?
that's my understanding, yes.
Okay. Do you know what the name of the company that pulled the permit, if you know?
I don't know offhand.
Okay, fair enough. Now, Would your opinion be affected at all if you learned that the city came out and inspected and approved the installation of the yard drain?
No, I mean, in my mind, it's still a bad idea to
Okay.
tie it in that manner.
Okay. Do you know whether or not there was an engineer consulted by the installer?
I have no idea.
Okay. Would you characterize that as good engineering or bad engineering, the way it's designed?
Objection.
Overruled, you may answer.
Okay, I think it's bad design practice to do it that
Okay.
way.
Would you expect that after that yard drain was installed the way it was installed, would you expect there might be noticeable water intrusion in the basement after that?
It depends on a lot of factors regarding the water tightness of the basement to begin with, but it certainly increases the potential for a water problem because you've increased the amount of water that is now finding its way around the foundation substantially.
Can you describe the grade of the property as you observed it when you inspected the property? You started to explain that a little bit, but can you go into some greater detail and describe the grade of the property?
Sure, it's generally pretty flat, so there's nothing here that is very steep at all, but it generally drains from back to front, pretty uniformly from back to front. There's a little bit of a low spot right in front of the garage, as evidenced by the trench drain that's in the garage or in the driveway, because that's needed because water collects at that point, but it generally from back to front.
Okay, there has been testimony in this case that ponding has occurred in this area, or ponding did occur in this area prior to the installation of the yard drain when you'd have heavy rains. There's been testimony to that effect. Were you aware of that?
Yeah, yes, I think there was some commentary in the ER report about standing water in the backyard.
In your professional opinion as an engineer, does the mere fact that after a very hard rain some puddling and ponding occurs in the backyard, does that evidence chronic drainage problems at the property?
No.
Can you explain why?
Well, I found that everybody's tolerance for rainwater and puddling is a very wide-ranging thing. Some people have the expectation that their yard should always be dry. And the fact of the matter is, given a relatively flat yard and a heavy enough rainstorm, if there's any low points, the water's going to stand for a little bit. There is a thing called a percolation rate with soil that water can only move through soil so fast. So if you get a lot of rain that falls and you've got a low area, that water's going to stand there for as long as it takes for it to soak into the ground and to evaporate, unless there's something that's going to move the water, like a swale or something along those lines, or a ditch that's going to move it one direction or the other. It's not uncommon. All you need to do is drive down the road and look at, the roadside areas after a really heavy rainstorm, even for days afterwards. There may be some puddling, some dampness. Even now, this time of the year, the yards are wet all the time.
Yeah.
As a result of the weather.
Observing the weather and the rainfall and precipitation, is that part of your calculation or part of the information you need to know and to do your work for the various municipalities you're working for?
It is. We deal with statistical rainfall events when designing storm sewer systems and stormwater management facilities. But also, given what I do as a city and village engineer, what I have to do is understand rain events and how those rain events might play into some of the problems I'm investigating. So I get a daily email from the Northeast Ohio Regional Sewer District that shows all the rain gauges all over Northeast Ohio and how much rain has fallen. And just because it's rained an inch over here doesn't mean it's rained an inch over there. So those rain gauges all throughout Northeast Ohio are critical to understanding how the rain's falling in the area.
Have we had significant rain events in this part of this area on the east side of Cleveland in the past 10 years?
Absolutely. In fact, going back to about 2011 in my industry, that's when we actually changed from using one particular set of rainfall statistics to using a different set of rainfall statistics that uses a model that uses much more intense, shorter duration rainfall events for us to do our design work, because it was found that many of the old models were not really accurately representing rainfall events that were happening. And I think, I don't think you have to be a professional and lived in Northeast Ohio over the course of the last 15 years. It's been in the news. You can see it. We have had some real gully washers in terms of very high intensity, very short duration rainfall events, where you get like an inch in 15 minutes, that are, it's a shock to the system when those kind of events occur.
So the very short, intense rainfall can cause puddling and ponding in the backyard of a normal property. Is that right? It
can. Just for instance, typical storm sewers we use, I'm sure you hear about this on the news all the time, but 100-year storm. You hear that everybody always claims 100-year storm when there's some sort of flooding. But, we design storm sewers for 10-year design storms. So at a 10-year storm, which is a lot less intense than a 100-year storm, the storm sewer pipes are flowing full. That's our design criteria that we use. And at 25-year storm events, the water is generally going to be up to the surface of like all the catch basins and the manholes, maybe over the top of it, depending on the geometry of the system. And then once you get over and above a 25-year storm, so you get your 50-year storm, your 100-year storm, you're going to have surface flooding everywhere. Roads, yards.
Is that regardless of whether or not the property has a drainage problem or not?
That is correct.
All right. Alex, can we have plaintiff's exhibit 15? Did you observe some photographs showing some ponding in the backyard of Mrs. Kinez's home?
I did. In fact, I took some as well. This is most of the ponding that I witnessed was on the adjoining property.
Oh, okay.
At the time.
Okay. Exhibit 15 has been represented as showing ponding that occurred sometime in the fall of 2021 at the Kinez property. As you're looking at this, what sort of, in your professional capacity, what are you seeing here?
I'm seeing a lot of water ponding. I'm not sure exactly what time of year it is, but it could be spring after the snow's melted. The area is pretty poorly drained and there's some ponding water, or it could be, in proximity to some rain event.
Okay. Would you expect this ponding to drain out eventually?
Yes.
How long could you estimate it would take this water to drain out of the property?
I mean, environmental conditions being with there, it depends how much rain we got before. So is the ground already saturated? How warm is it? Is it going to evaporate, etc.? But, in the summertime after a rain event like this, I would expect that would likely dissipate over the course of a week or less. In the springtime, it might hang around for a while as we continue to get more rain and the weather stay cool.
Eventually it'll dry out, though?
Yeah. I mean, in looking at a picture like this, if that area were wet all the time, there wouldn't be any grass growing. So I can see that there's grass growing underneath there, that the grass is submerged, which tells me that it's going to drain out and the lawn area is going to reestablish itself once the water drains out.
I see. So you would see evidence of a chronic water drainage problem by observing the state of the grass?
Yeah, typically if there's going to be something, if it was submerged like that all the time, the grass wouldn't grow. So
okay.
It'd be a big, bare mess.
Okay. Have we had a 100-year storm in the near past in this area?
I don't remember exactly, but we definitely have. Yeah, and they've been pretty localized too.
Okay. Mr. Courtney, have all your opinions in this case today, your testimonies today, all your opinions, have they been to a reasonable degree of engineering certainty?
They have.
Okay, thank you very much.
Mm-hmm.
All right, cross-examination, Mr. Greenberg.
Okay, I'm gonna need access. Mr. Courtney, my name is David Sternberg, and I represent Ms. Knez in this matter. Now, you were retained in December or 2023 or early 2024?
Correct.
Okay. And who were you retained by?
Craig Bashine.
Okay. And was there a fee for your investigation?
There was
And how much was that fee?
$1,500.
Okay. And are you being paid for your testimony today?
Any court appearances like this, I charge on an hourly basis.
Okay. How much are you paid an hour?
$175 an hour for this type of work.
Okay. Now, I noticed in your report, you list a number of documents that you looked over. And one of them you referred to in your testimony, and that was the loss history from the insurance company. Is that correct?
Correct.
Are you aware that Mr. Schubert of State Farm testified yesterday that the water problems that Ms. Knez is complaining about, such as the backyard, such as the water coming in at the base of the wall and the floor, would not be covered by insurance?
I'm not aware of that.
Okay, well, that's what he testified to. So there wouldn't be any history, isn't that correct?
I have no idea.
Okay, well, if there's no coverage, would there be a history of a claim?
I'm neither an insurance expert nor privy to the details of the homeowner policies that were in place at that time regarding any coverage related, exterior or interior.
Yet you related on a report that said what from the insurance company?
That there was no loss history as it relates to.
And you would agree they would only show loss history that related to their policy.
Objection.
Overruled.
They would show loss history for anything that would be a covered loss over the period of that
Right,
time.
a covered loss. Now, I noticed also you were aware of Ms. Knez's letter to Mr. Zevnik of December 8th, 2021, correct?
Correct.
And you were also given copies of the letter that I sent to Mr. Zevnik and that his attorney sent to me. Is that correct?
Correct.
And those were in the spring of 2022. Is that correct?
Let me take a look. Letter from Knez to Zevnik regarding water issues was 12/18/21, and then the letters from you to Zevnik and from Bashine to you were April, May of 2022.
Okay. And when you looked at the property in January of 24, correct?
It was January 8th of 2024.
Okay. Were you aware that the water problems had been corrected over a year before?
I was aware that work had been done, not that the problems had been corrected completely.
Okay. And I noticed in your report, I believe there's a commentary that there was no one there to tell you what the water problems were being complained about?
No, I think I made the comment that in the ER concrete report that he references particular type of water intrusion into the basement, that the water's coming in between the joint in the floor and the wall. But that's the only commentary that's offered. There's not any specific location. There's not any pictures. There's not any further explanation, just that general comment.
Did you ask for any further comment?
I don't believe so.
Okay. So you didn't have any further, you didn't ask for any further comment, and this was approximately 14 months after the work had been completed, correct?
Correct.
Okay. It is also over a year since there was mold remediation. Is that correct?
I'm not sure the date the mold remediation was done.
Okay. Wouldn't that have been important to you?
I'm not reviewing a mold problem per se. That's not my expertise. I'm reviewing a drainage problem.
Well, you said one of the signs of a basement with a water problem is a moldy smell, right?
No, I said a damp, musty smell.
Okay, damp, musty smell. If the problem had been corrected, and if the basement had gone through a mold remediation, would you still have that smell?
If the problem had been corrected
Yeah,
and there's been some sort of major remodeling, it's possible.
it's possible. Okay. When you looked at the basement, what was the condition of the basement when you looked at it?
I remember there was a lot of Star Wars collectibles.
Okay.
I'm a Star Wars guy. I was easily distracted. Sorry.
Okay, what else did you notice about the basement?
Very clean. Everything appeared freshly painted. Everything was clean.
Everything was freshly painted?
Yeah.
Well, if everything's freshly painted, would you expect to see watermarks?
I'm looking at the joint along the floor. I'm looking at the top of the wall. So it's possible that I could see some things that could have the efflorescence. You may not get the paint that would take in those areas. No real water staining on the floor, no subsequent water staining on the walls, even though they've been freshly painted.
Would you agree with me? If the problem had been corrected, the mold had been remediated, and the walls had been freshly painted after such, you wouldn't expect to find such signs that existed before these steps had been taken?
It would make it more difficult.
Do you know why you weren't called to investigate the water problem prior to it being fixed?
Do I know why I wasn't called?
Yeah,
I have no idea.
okay. And from your investigation, you can't tell us what the ponding was like in that backyard prior to the yard drain being installed, can you?
With there being a change in conditions as a result of the construction, no.
Okay.
With the exception of being able to rely on historical aerial photos, which I typically do.
Well, what did your relying on historical photos tell you?
That the backyard is generally flat, drains from back to front, and I was able to see the construction for this particular.
So you didn't see any photos of what the backyard was like in wet season or after rain prior to it being installed the yard drain?
The spacing of the photo, there may be one photo that's taken every year or every couple years, so the spacing of them are not as accurate as, would be needed to really pinpoint certain points in time.
Okay. You've already looked at Plaintiff's Exhibit 15, and I think you said a ponding of that nature would take a week, maybe more to...
It depends on a lot of different factors. So.
Okay. This testimony was this picture was taken in the fall of 2021. So it's the fall season. And you can tell the nature of the pond. So what's your best estimate on that one?
In terms of how long it would take?
Yeah.
Again, there's many factors that go into it that I can't answer specifically. I was trying to give for instance, that if you're in the spring with saturated ground versus summer with not a lot of rainfall beforehand, you're going to get wildly different lengths of time that water may dissipate.
Show you what's been marked as Plaintiff's Exhibit 16. which is a picture at a different time regarding ponding in the backyard. Can you give us any type of estimate as to the nature of that ponding, or how long that would be there?
No, it's very difficult to even determine where that is.
Now, if I
Can we
recall,
approach Your Honor?
Sure. Sternberg?
thank you, Your Honor.
You withdrawing that question?
Yeah.
All right. Question is withdrawn. Ladies and gentlemen, just to remind you, as we're going to get there, what the attorneys say throughout the trial is not evidence. Evidence comes from the witness stand, the exhibits, and that's what their decision needs to be based on. Mr. Sternberg?
Thank you, Your Honor. Mrs. Courtney, this is a picture that was, a video that was taken the same day as
Come
the
through
picture
grass,
prior,
because it's just as squishy.
standing, plaintiff's son standing in water. How would you describe that ponding effect?
Looks to be, I don't know, maybe about 4 inches.
Okay. How long do you think that would stand on the ground?
You know, again, as to the length of time that water is going to remain standing, I mean, I can't answer that question. There's many environmental factors that go into answering that question.
Picture of the backyard at a different time, plaintiff's exhibit 12. Did you see the ponding?
Is that taken from the house looking towards the back of the property?
Well, can you see what is the back of the property there?
Well, again, you know, I'm trying to make sure that I'm oriented properly.
Okay, that's looking at the back fence line.
From the house.
Well, from the upper part of the backyard.
Okay, I can see ponding on there.
Okay. If you were purchasing a home, would you want to know about that ponding?
Yeah, I suppose.
You suppose? Does that mean yes, you would want to know about it?
I would want to know about it, but I mean, I'm kind of in a unique circumstance that,
Because
you know,
you're an engineer.
yeah, my house is on top of a hill, so.
Well, if you're the average Joe like me, would you want to know about the backyard ponding like that?
Yeah, I would want to know.
If you asked about it, somebody didn't disclose it to you, would you feel that they were less than truthful with you?
Can you ask that question again?
If you inquired of the person you were purchasing the home from about water problem, drainage problems, and they failed to disclose to you that ponding in the backyard, would you feel they were untruthful with you?
In that instance, I suppose, if there was a specific question that was asked.
You suppose? Okay. Now, you take issue with the backyard drain being tied in to the downspouts, right?
I do.
Okay. But that's code in the city of Willowick, isn't it?
I'm not sure if that's, well, if they approved it, they must allow it, so.
Okay. And were you aware that the catch basin in the driveway was tied down to the downspouts also?
The catch basin in the driveway, I think that was replaced at the time that the driveway was replaced.
Yeah, it was tied into the downspout.
And I think it was reconnected the same place that it was connected previously.
Okay, and where was that place?
I think it goes into the downspout of the garage.
Same thing they did on the other side of the house, correct?
A little different.
Both approved by the city, correct?
I'm not sure.
Do you think it would have been beneficial to you in inspecting this property if it would have been done at an earlier time before the work was done?
Yes.
Do you feel that you've been precluded in a number of areas of an inspection because it was put off over a year after the property had been corrected?
I don't know if I have an opinion on that or not. I don't feel as though I was necessarily excluded or precluded from anything.
Okay, but don't you think it would be far more helpful if you would have inspected it while there was a problem going on?
Anytime I'm involved with anything, I tell my clients, the earlier I'm involved, the better off it is.
Okay. Does the city of Gates Mill, the village of Gates Mill, require an engineer for a yard drain?
To engineer it?
Yeah.
Anytime anybody's proposing any sort of a grading project where they're going to be changing the elevation of their property, installing any sort of drainage, I go out and look at it, and depending on the complexity of it, I will advise them whether or not they need to hire an engineer to put together a plan.
Okay.
Or whether or not it's something I feel I can instruct them about in my capacity as their village engineer.
Okay. But the city of Willowick, to your knowledge, doesn't do that.
I'm sorry?
The city of Willowick, to your knowledge, doesn't do that, does it?
I'm not sure.
Okay. Do you have anything else you want me to ask? No. Nothing further, Your Honor.
Redirect examination.
Yes, thank you, Your Honor. Mr. Courtney, staying with that topic that Mr. Sternberg just raised, were you aware that the permit to put in the yard drain was applied for by a company other than the company that installed it. Were you aware of that?
I was not aware.
Were you aware that the person who installed the yard drain never looked?
Objection.
Approach, please. Go ahead and re-ask your question, please.
Okay. Were you, Mr. Corney, were you aware as part of the application process, a diagram of the design of the drain, yard drain, was submitted to the city of Willowick?
No.
Would that be uncommon in your experience?
No, it would be very common.
Okay. Would it be proper for the person that actually installed that yard drain to have never seen the diagram that was submitted to the city?
It's a little unusual.
Would that be good practice in your opinion?
No, I mean, if there's a diagram that's been submitted for the permit, they should be following that plan.
Okay. The driveway that was installed has this curtain drain in the back, which replaced an earlier drain that was already original. Is that correct?
Yeah, there was a little circular catch basin that was at that same location in the old drive.
And to your knowledge, it was installed, or I'm sorry, hooked up into the downspouts. The new driveway and curtain drain was hooked up the same way as the old one was?
Correct. Based on the photos that I saw, it looked like that same connection point was maintained, and it just was a trench drain instead of a circular drain that was used.
Okay. The drainage area of the driveway, can you describe it? Do you know what the square footage of that would be?
I mean, that driveway right there is probably the square part of it's probably 24 by 24. So.
And this area would be the drainage area feeding to that drain?
Correct, yeah, because the rest of the driveway drains out towards the front.
Is that larger or smaller than the draining area that was created by the installation of that
It'd
yard?
be much smaller.
Much smaller?
Yeah.
And the drain area from the yard drain would be much larger than that?
Yeah, and you could see with some of the pond, I mean, you could see with some of the photos of the ponding, that was collecting in multiple yards.
Yeah.
Back there.
But you can see even from this photograph that there seems to be grass growing at the borders of each of those adjoining homes.
Yes.
Okay. And if there existed chronic water problems in that area, you would see what with respect to the grass?
If it was submerged all the time, you would typically see the grass dying back. You would have bare dirt that you would see, along with probably some lichens and mosses and those sorts of things that would be growing in
mushrooms?
Potentially. I mean, that's more nutritional, but yeah.
Okay. And we don't see that in this photograph with the adjoining properties, do we?
We do not.
Okay. Your Honor, can I have access? Okay. One before that, prior to that. This is Exhibit A. These are photographs that were in your file of the property that's at issue in this case. Do you recall reviewing these photographs?
Yeah, I believe these are the ones that, but unless they're the historical ones that were provided, they could be the ones that I took on January 8th. I'm not sure which ones they are.
Well, I'll represent to you. These are listing photographs that were taken in August of.
So the historical photos folder.
Right.
Okay.
For the listing of the property when Mrs. Knez purchased it. as you observe, what do we see here? What are we observing in this photograph?
You can see the back of the garage with the downspouts on it, and you see the fence on the left of the picture is the rear fence line.
Does the photograph depicting the state of the grass area indicate to you a chronic ponding water problem?
No, it looks like a pretty healthy lawn.
Okay. Can we go to the next one? And this photograph also, does this photograph indicate to you or provide evidence to you of a chronic ponding water problem?
It does not.
Okay, thank you. You indicated that that the installation of the yard drain greatly increased the amount of water that was going to be feeding into the downspouts to the home. Is that right?
That's correct. So all that water that was around that rear property line, before it was in the yard back there and it was soaking in, evaporating. Now it's running right along the foundation of the house. And it's all competing to get out of that 1 6-inch connection.
Would it be possible, in your opinion, that within 2 weeks of the installation of that yard drain that the homeowner noticed water intrusion into her basement? Would that be possible?
I would say it would be possible.
Okay.
Depending on what was a closed system around the house, with the exception of the garage drain. Once the yard drain was installed, now that whole rear yard area, that's all draining around the foundation of the house.
Okay.
So if that work was done and then there were subsequent rain events that led to water in the basement, that tells me a lot.
Okay. And it's possible that the noticeable water could be observed in the basement 2 weeks after that yard drain was installed?
There's a much larger supply of water to around the foundation of the house at that point in time. So yeah.
Okay. Now, when you inspected the property or came to the property and looked in the basement, the testimony is that was after the yard drain had been installed and it had been waterproofed. Is that correct?
That's correct.
Now, you talked about evidence observing a basement where you might see evidence of long-standing water problems. And one of the things you talked about was efflorescence, and I mispronounced it.
Efflorescence.
Efflorescence. Efflorescence. Now, even if you've solved the water problem, are you still going to see the stains and the efflorescence on the block wall?
If there is a fresh coat of paint on the walls, it may be difficult to see it. But typically, what happens in those areas that are effloresced is they can be difficult to hold paint. So you may get some bubbling of the paint. You may get some of the paint peeling off.
So you didn't see any of that?
I did not.
Okay. When you were retained to consult on this case, did myself or any prior lawyer or any other lawyers tell you in advance what opinions we wanted you to come to?
No.
Were you influenced in any way by any of the lawyers who retained you as to what your testimony needs to be in this case?
I was not.
Now, if a particular installation of a drainage system like the garage or the yard drain, if the city comes out and approves it, is that, in your mind, conclusively demonstrate that it was installed using good engineering fundamentals?
I don't know about engineering fundamentals, but I guess it met the basic building code requirements that they had.
Okay, but that doesn't mean it's good engineering, does it?
Not necessarily.
Okay, and in this case, does the fact that the city came out and approved the installation, does that change or affect your opinion as to whether this yard drain was properly installed?
No.
Why not?
Well, again, pictures helping, all that water, the water that was in the backyard around the rear line on the adjoining property, any of the water that was standing on this property is now given an invitation to come right around the foundation of the house. And, if it were a smaller area, if it was a patio drain that had a very isolated area, that's maybe one thing, but not, taking a perceived water problem and then correcting it by putting in a yard drain to a downspout. Typically if you're going to put in a catch basin, the smallest pipe that you're going to have outletting from it is going to be 12 inches in a typical catch basin installation. Some yard drains may have smaller pipes, but that's how quickly stormwater can accumulate, that the smallest pipe that we'll typically put into a 2x2 catch basin is going to be a 12-inch pipe. It does not take much water to overwhelm a 6-inch pipe during heavy rain.
Wouldn't a city official deciding to approve the installation have thought of that?
Maybe.
Okay.
You know, a lot of times I found with municipal building departments, hey, is there a pipe there? Is there a catch basin there? They'll allow a connection to whatever convenient connection point there seems to be there with not a lot of regard to what's going on downstream from there.
All right. Do you know who inspected and approved the drain?
I do not.
Okay. If I was to represent to you that it was the chief housing and zoning inspector, would you believe that is the appropriate profession to have inspected the drainage system in this case?
Yeah, I believe because they probably looked at it as more of a plumbing job.
I'm sorry.
I said they may have looked at it as more of a plumbing job.
Okay.
So.
All right. Thank you very much.
Cross-examination.
Yeah. Could you put plaintiff defendant's exhibit A back up?
Or you want their exhibit?
Their exhibit. Okay, I guess, what's the next vote on that? Mr.
Wait,
Clerk?
what is this, just for the record?
That's part of the series of pictures they
Oh,
have.
part of defendant's exhibit A?
Yeah.
Okay.
Your testimony is that is a healthy looking lawn?
Well, I mean, there's grass growing, and notwithstanding any nutritional needs that it may have, there's perhaps replace healthy-looking lawn with. I don't see any visual evidence on that photograph that shows me that there's a long-term standing water problem in the back of the yard by loss of grass plant growth, mud, lichens, and mosses. The things that would typically kill a lawn because they're going to be submerged for a long period of time.
And if I told you there's been testimony by neighbor that both her house and this house had standing water in the backyard during rains, would that surprise you?
No.
Okay. And there was testimony by Mr. Reed, who was given the job by the company that had filed the permit because they didn't have the capacity to do it. And they had gone over with him the specs for the job. Would that satisfy you that he had looked it over to the point of what the permit had been filed with the city?
Well, from the question before, it sounded like he didn't have the plan with him that was the plan that was to be followed. And pet peeve for me, I'm the guy that generates the plan. So anytime I walk on a construction site and say, do you have a plan? And the answer is no, it doesn't start in a good spot.
No.
So I would expect anybody that's building a project that's based on an approved plan for which a permit has been issued to have that plan on site while the work's going on.
He testified as to what the plan was from the information given to him by the man who pulled the permit. That was satisfactory for the city.
Objection.
Overruled. No, that's a statement, ask a question.
Okay.
So it's a statement phrasing the question.
If it wasn't satisfactory to the city, wouldn't they have called it to his attention at the inspection?
I don't know, I'm not the city.
Nothing further.
All right, sir, you may step down.
Thank you.
Thank you very much.
Thank you.
Okay, City Council, please. Fogarty, does the defense have any further witnesses?
No, Your Honor, the defense rests subject to the admission of the exhibits.
Mr. Sternberg, any rebuttal testimony on behalf of the plaintiff?
No, Your Honor.
All right, ladies and gentlemen, both the defense has rested. Plaintiff has no rebuttal testimony. That means you've now heard all the evidence and testimony each side in terms of presenting the trial. There are two steps that have to be completed before you get to beginning deliberations. The next step is, of course, going to give you the instruction to go off, and then the parties are going to make their closing arguments. Before we get to that point, there are legal matters I need to address with the lawyers outside the presence of the jury. So we're going to take a break here. We'll take a very brief break, and then we're going to come back in here and do what we need to do. And then we'll see how long that takes us to decide. We're probably going to take a little bit of an early lunch and then come back earlier during the normal lunch hour, and then we'll start with closing arguments then. But let me see how long this takes first before we do that. We're going to take a break. Please remember, even though all the testimony has been presented, evidence has been presented, you're still not allowed to talk about the case with each other. So don't start that yet. No talking about with anyone else or don't want anyone to talk about it in your presence. No investigating or researching any issues involved in this case. So what I'm going to ask you, if you're found in the jury room, if you want to go take a break and use the restroom, step outside a little bit. But I'm going to ask that you remain, once you're done with that, come back to the jury room and stay in there. Don't remain out in the hallway. And we'll take about 5-minute break and then come back in and discuss it.
Did you all see that? Yeah, no, you did good. Really good. I think Courtney did really good. You did.
I wanted to make sure, I mean, I hand you a whole packet, that will be updated, I just want to make sure it's okay, thank you.
I've had it like right here the whole time because I didn't want to lose it.
Yeah.
And then he came over and picked up some exhibits and there it was.
I heard you glanced over at like something from.
I know, and I didn't want to say anything because I was gonna ask you something, Judge, because I thought maybe your phone went through, that's why I got up. But then I thought, okay, I can't do anything about it. But then, like I said, then I like looked over there and I saw it and I was like, okay, I'm losing it.
Yeah.
That's how he works in court.
Oh, is that
When
one?
I go against him,
Well, those guys don't get paid shit. You gotta have some sympathy for them.
some actually.
Are we gonna replace this?
Yeah,
Okay,
I'll give her this whole one.
okay.
Yeah.
Thanks for doing all that.
Yeah.
I know you did it last night. I appreciate it.
I messed up, I switched up 2 letters, I'm just making sure they're right with what she has up there.
Okay. We actually don't, we will submit it the way that is. We don't even have to have a list.
Oh, okay, well, I'll do this too.
So you can move the rules with you and your for closing,
Inspection, or the instructions. You can go with the instructions.
and then he'll probably do the instructions, go to lunch.
I don't know. He might do that. Actually, he said he was gonna go to lunch early. Usually, we have to,
I know instructions and then goes right to, like,
we have to do our exhibits first. So, I'm gonna do my directed verdict. And I'm gonna strike the punitive damage aspect of the case.
Dennis, do you want this mold testing thing, because he rejected it yesterday, but just, he kept calling it a report, and it is, but just say it's the results of the test that she did.
No, he won't want that. He won't let us have that. Did we
I think
mark it?
No, but we did during, it was that one thing that showed her bedroom, this page that he
Yeah,
said,
but
no.
he wouldn't let him get it there.
Okay, the only reason I thought he didn't is because it sounded like it was like an expert report that was typed up. I mean, report just means it was the results of it. The person didn't give his opinion, and he testified.
I know, but it's not. Did we mark it?
I have it in here, yeah.
Mark, okay,
Okay.
then we'll withdraw.
Yeah. Yes, I did. It was so annoying.
I don't know.
What happened?
She just would like turn around and look at him and then just shake her head. At the most random parts.
I'm not even correct.
Right. Yeah. No, no. It's more like, no, you did it. You did it really good.
Top 10?
Yes.
Our judges, proposed jury instructions in the verdict form. We'd like you to go over each of them, and then when everyone's ready, we'll come back out.
Okay.
Oh, good. Are you plugged in? I saw your dad.
I am,
was
yes.
on. Okay.
Thanks for, do you want me to have anything up for closing?
Yeah.
You can just tell, yeah, I mean, I can just pull up.
Well, I'm gonna use the PowerPoint again.
Okay.
And I think you said there was a date that was wrong
Yeah,
in
yeah, I'll
that.
change it.
Yeah, if you could just fix that. He just makes this shit up on his own.
Really?
Yeah, he's just, I don't know what he's like in a criminal case, but he's just fucking making shit up. This is the statute, you have to follow the statute on punitive damages. He's gonna have them consider both liability and punitive damages in the same deliberation. Now, they're not gonna get the fucking punitive damages, you have to have clear and convincing evidence of that.
No.
I'm just gonna point that out.
You had a chance to look everything over?
Yeah,
Okay.
yeah. We're almost done now.
I know this is the nervous part now.
Yep. So they decided not to call a rebuttal witness.
Thank God. Because then he would have to call me back up, right?
Maybe. I don't know where it would have gone. Ooh. Oh, I see. Okay. he's gonna complain, there's no line for compensatory damages anywhere.
Oh.
Huh?
Who am?
Yeah. There needs to be another interrogatory that says, if you find for the plaintiff, you must determine how much compensatory damages to award. And they don't have a number, they don't have a line for that. Maybe I'm missing something. Thanks for everything.
I appreciate both.
Yeah, are you able to juggle your law school stuff with this?
Yeah, I start finals next week, or, next week, they just have 2, so it's horrible, but yeah, I got it.
What classes?
Constitutional liberties and criminal procedure.
Constitutional liberty, is that different than con law?
They pretty much break it up into 2 semesters. The first
Right.
semester is like constitutional powers, and
Yeah.
this one's,
We just had con law 1 and con law 2.
yeah, it's pretty much that.
How did this get up to 75 degrees?
I know, I just looked, I was sitting there going, it's getting hot.
Maybe it's warmer outside. It rained, it drizzled a little bit outside.
I thought it was cool.
Get drizzled?
Yeah,
Oh, great.
new puddle.
No problem.
I thought it was,
It was supposed to storm today, they said.
yesterday.
Well, yesterday luckily passed over.
Yeah, we missed all that.
Yeah, I went home and did 13 bags of grass.
After trial?
Yes, I had to clear my mind.
So you mowed the lawn?
Yeah,
How big is your lawn?
almost an acre.
Oh.
7.8.
Mine's 0.6. But I have landscapers. Carlos, he used to come with like 5 guys, now he comes by himself.
You know John Hackett.
Who?
John Hackett. He owns Johnny's Car Wash.
Oh, yeah, I do know him
He
actually.
lives behind me. He's the one doing the refurbishing on the road. So he took all the trees down.
So he has the ice cream place and the car wash.
And he's opening,
My son was worked for him.
he's opening a restaurant right next door.
Really? On Friday?
Yeah, so if you go over Ravenna, once you pass the
Yeah.
90,
Yeah.
you got the big bar.
Is that the what?
It's a big bar. It's a big bar. Making the old living space.
Oh, I know.
First car.
Oh, okay.
And then you took down all the trees. So now you see my house in Ravenna.
Ravenna and
Sturbridge.
Sturgis, okay.
Ravenna or Somerset, I'm sorry. So when you go past 608,
Yeah.
go over 90,
Yeah.
straight out of left.
Oh, okay. Yeah.
You'll see his barn with all the construction.
Oh, I'm worried. There she is.
This happens when the bailiff's late.
All right, so we are back on the record at this time outside the presence of the jury. Second?
I don't have your exhibits.
She's got it.
Well, we need all the exhibits that have been identified have to be up here.
Yeah.
I mean, she's responsible for them.
You got it?
Yeah.
Yeah.
And this is correct?
Yes,
So I give it this one?
yes.
Okay. So we have, you're the duplicate copies of those.
All right, so the defense is rested. They move for the admission of exhibits. What exhibits are we talking about, Mr. Fogarty?
Defendant's Exhibit A is the listing photographs that we looked at.
Any objection, Mr. Sternberg?
No.
All right, the A will be admitted.
Exhibit B is the actual listing that Mrs. Peterzak identified, the listing that was in the
Any
online.
objection?
I'm not quite sure I know the relevance of it.
So we can withdraw it.
You withdrawing it?
Yeah.
We still need bigger bits.
Yeah, still need it, but we just won't, we'll separate it.
Oh, you'll do that? All right.
Mary will do that.
Okay. Yeah, Exhibit B is withdrawn.
Okay, C is the aerial photos. Aerial photos.
It is a copy of the photo that I have blown up over there.
Any objection, Dave?
No.
A, or C will be admitted, the 8 by 10, okay. D is insurance loss histories. Do you move for the admission of that?
Moving to admit that, Your Honor, that was identified by Mr. Schubert.
Mr. Sternberg?
No.
That'll be admitted. E is sewer records from the city of Willowick.
Right, that were identified by Mr. Shannon.
Any objection?
No.
Exhibit F is the letter from Ms. Knez to Mr. Zevnik on December 8th of 2021.
Any objection?
No.
That's submitted.
G is the Courtney report, which you do not.
Yeah, the report itself's not gonna come in.
Right, the report itself is not coming in G. We withdraw that.
Same with H?
Well, H is actually, I called it Courtney report exhibit, but it's just the 2011 home inspection report. That's all it is, that Mr. Korosik identified. That's all it is.
Why does it say Courtney report? Is that just a mistake?
Yeah, it's a mistake. That's the manner in which it was transmitted to Mr. Sternberg.
It was part of
Okay,
Mr.
but it has
Courtney.
nothing to do with Courtney.
No,
It's the home inspection.
Home
report.
inspection
Any
report.
objection there?
I'm not going to object.
That's admitted. And videos of property,
that's withdrawn. That's withdrawn.
J is withdrawn. What, Mark?
It was some kind of report,
What-
Mark.
What is?
Use of video, I don't think it was, I don't know, it was a report.
Oh,
Yeah,
is there a J?
There is an I, which is a photo of the slop sink after Mr. Reuter installed it, which was with the,
All right.
with the,
Hang on.
Oh, is there a J? That's
So-
on the video.
It says videos, which they didn't do. So there is an I, right?
yeah, there is an I, and
That's
it
the
is
sink.
the photo of the sink.
Any objection to that?
I got to recall it. It's not part of this.
It's up here then, Mayor.
It's this, David. David, it's this.
So with the white pipe underneath?
Yeah.
Okay, I'm confused.
Yes, so am I.
This is marked as I.
No, that is not an exhibit.
Well, then why is it up here?
I don't.
And why is it marked as an exhibit?
I can tell you why it's up there, but it's not really that important. During
Well,
the
I gotta
trial,
make sure stuff doesn't go back there that
Okay.
shouldn't go back there. You're giving
during
us
the
stuff.
trial, and I don't know why Mr. Sternberg, I think absentmindedly took that off my desk and put it up there.
Well,
I'm
but
not
you
blaming
used
But
it
you
for
just
the
gave it to
trial.
us.
No, I have it as, I did not intend to introduce it as an exhibit.
Okay, well then wait a minute.
The packet that I gave you is everything that we've introduced, that we've shown on the screen, and that we've sent to the jury, okay, yeah.
I have extra.
All right, so where's I?
I
have-
is here.
Well, are you moving for its admission?
Yes.
Then it needs to be up here.
Okay.
No, I got that.
He
You
has,
have
he
it.
has that.
That's why I asked where it was. You said you had it. I didn't know it was.
Well, the difference was you were saying.
I said, where's I? You said I have it. I don't care.
The description you gave of I and what was up there as I were two different things.
David, this is not I. This ended up on the desk because you grabbed it and put it up there.
Well, it says
Well, the only reason I was added is if you used it.
No, it was never intended to go
All
up
right, don't
there.
worry about it. All right, so where's I here?
I is in that packet.
Supposedly everything's in here, Judge, but then I have these that are also marked E and J, and I don't know if they're the same things that are in there or not.
That's why when the exhibits get identified, they need to be left up here. They can't be going back.
Here's the problem.
Once they get identified,
Here's-
they're Mary's
here's the problem,
responsibility.
Dennis.
All these are.
You told me that I was the photo of the basement slot sink. I look at your packet, and that's identified as K. It has I as being what you accused me of taking off your desk. I would have only had it if it was for purposes of cross.
Give me that packet. Can I have that packet, please? It's not good.
It seems confusing, but it's not, Your Honor.
What?
It seems confusing, but it shouldn't be.
I believe this is my error, there's just some lettering that I think got mixed up. If I could clarify, this one does have it marked, has the photo marked as I can show you, and it goes along with that as well.
The packet you have, Your Honor, has that marked as I as well. Correct?
Maybe I'll switch them out, it did not, I have it. May I approach them?
Your Honor, can,
Just wait, please. So B is being withdrawn, right? Just the listing?
yes.
What is?
B, so here it is, I'm gonna set it aside. I'm gonna have to do all this. I should not be having to do this. Aerial photo, I mean,
Yes, Your Honor.
yeah, but I don't know what this exhibit is. These are what's going to be part of the record, and there's an exhibit sticker that just says exhibit, nothing else underneath there.
I have one with Bates sticker.
That's what I need then.
Okay, but that's just not,
These,
Do you have it?
yes, this is the whole entire packet. Everything's Bates stamps and has the exhibit stickers on it that should clarify everything.
I apologize, Your
and this is what's gonna go to the Court of Appeals if that ever happened, but.
Honor. Okay, this is the packet to work from, Your Honor.
Your Honor, it's my understanding Stan took exhibits as they were, exhibit numbers and letters as they were used in trial. Is that correct?
So Mary does, so do I.
I can't sometimes do
I
it.
mean, sometimes you don't do it, but yeah.
But, see, I just, I don't know. This name,
Stan wrote I as a letter.
yeah. And I
Not a
have J as a,
photograph, a
I have
letter.
J as a report.
J is / report. Stan adjusted that as well.
The I is the letter from Ed Reed, which we are withdrawing.
Yeah, but you just said was the photo of the sink.
Yeah, I don't know what happened.
I don't know, they were,
Well, then I'm not gonna let any, why wasn't this done before I came back out here? I don't know what.
We've been working on it, Your Honor. K is the photo of the slop sink. I is the letter from Ed Reed, and we are withdrawing.
I thought I was a picture.
No, they were wrong about that.
Slop sink?
So I is what?
I is the letter from Ed Reed, which we are withdrawing.
All right.
K is the photo of the slop sink.
What's J?
J was the mold analysis report, and we're withdrawing that.
Mold analysis report?
Yeah, we're withdrawing that. It's per your instruction, Your Honor, that you don't introduce reports.
So H. I is the letter from Reed withdrawn. J is the mold analysis report. K is the sink.
K is the sink from the Rooter Plumbers, the photo.
Any objection to that, David, the sink photo?
No.
Is that it?
L is the photo of the caution high water area during heavy rain sign that was identified by Mr. DeFranco.
Any objection to that photo?
If I recall, he stated it had no relevance to this part of the street.
All right, well, I'm admitting L.
Yeah.
Still was properly identified, whatever relevance you want to give to it.
And M is withdrawn, Your Honor.
Is that it then?
Yes.
Do you have another copy?
I have all of them right here. I'm going to go through them right now and make sure. So for A, there's 10 photos that are part of A, which are listing photographs. Um, B is withdrawn. There. C is aerial photos. D is in history losses. E is sewer records. I mean, these should be like grouped. There's a whole bunch of E's here. It should be, if they're sewer records, it should be.
The E is all of the sewer records.
Yeah, but they shouldn't be like just individual pages with saying Exhibit 1, G1, Exhibit C, Affidavit of. you'll have like 10 pages, and only the first page has A, and there's nothing else on any other pages, so you don't know what exhibit that is, if they're not attached together. So.
You're correct, Your Honor, I apologize. G, we're withdrawing if we're at that point, Your Honor.
Wait a minute. G. Your exhibit list says G is the Courtney report.
No, Courtney report exhibit, purchase agreement.
No, purchase agreement.
And H is...
Hang on, please. Paper clips down there. Thank you. H is a home inspection report that's coming in, right?
Yes.
Now, Exhibit I is the picture of the sink. Exhibit I is the Ed Reed report, so there's two I's here.
Well, the packet I just gave you has the exhibit K is the photo of the pipe, white photo of the pipe, in the section I just gave you.
No, it's not. Here's the pipe. This is Exhibit I. And the next exhibit is Exhibit I, Exhibit Reed report. J.
Yeah, he took it back.
Hang on, Your Honor. This
And
is
there's no K.
This is exhibit I.
I have two I's up here.
This is exhibit I.
Yeah.
Well then, this is I. And you've argued, initially it said I was the sink, then you said I was the letter from
Your Honor,
Reed, now you're saying.
This was never submitted as an exhibit in this case. I'm not blaming anybody.
So what is that?
This is exhibit I. You have that.
Well, so I is the picture of the sink?
Yes.
You said it was K. You said it was I, then you said it was K, now you're saying it's I.
Is it K? It's K.
Well, it's labeled I.
Can you go fix
Yes,
that?
I'll fix it, yes.
I'll fix it, but is that what it is?
Yes.
So what was I? It's withdrawn, but I was the letter from Reed?
I was the letter from Ed Reed, which is withdrawn.
We still need it.
Yeah, it's gotta be up there, you can't withdraw it.
There was two of them you just took. I don't know if they were.
Give me that, please.
There was a J.
I have J here, if it's the same J. What J do you have?
Alice, can you
Give me that I back, please.
I'm getting lost. Was K used in evidence?
K is the sink, the white.
Okay,
pipe.
that was I used in evidence?
It was Ed Reed's report, it's not being admitted. But
Okay,
it's being, but it was identified, so it's gonna be part of the record, but it's not going back to the jury.
Okay.
You can judge whatever.
J is being withdrawn,
J is
mold
being
analysis
withdrawn.
report. Yes, that's right here. So I have that. Huh?
I don't have those.
I have everything here.
No, they weren't in that packet, they were marked different, they were marked the
Alright,
same
well-
orders.
I'll update it.
No, nothing's changing from what I have.
Right, there was these pages that weren't in there, that were used during the trial.
We're not admitting
I know,
it.
but you used them.
If you used them, they still need to be part of the record.
Okay.
I mean, it's a court of appeals has to look at this, and they're gonna. it's still something-
Exhibit K wasn't your exhibit.
K
You own-
is the sink.
I'm sorry,
They didn't call it K, I get it.
I have another K here.
Yeah.
That's the piece of paper I'm missing, that one.
What?
What you have right there, Dave.
This?
Yeah, but I'm trying to think
Mary-
what this was called. The one
I
he,
have that, I have everything.
yeah, that's the one he used.
That's
as an
not being,
exhibit.
that's J, that's the mold report, it's not being
Okay,
used.
what about Ed Reed's report?
That's
That's I.
That's
I have
I.
that too. I have,
Okay, sorry.
all right, we have everything.
okay. Apologize, Your Honor. Those are our exhibits.
Your Honor, I do have bait stamp for exhibit E.
You have what?
I have bait stamp for exhibit E.
We withdrew it then.
So it's okay.
Yeah.
But he's not.
Exhibit E is not withdrawn.
He's
Oh.
the sewer
No,
record.
it's a sewer record, so these are just the bait stamp piece for the.
I have bait stamped E.
Okay, I'm just making sure. They weren't marked.
I've never had to do this before.
Let's see.
All right, Mary.
I see.
These are the exhibits that are going back to the jury.
Oh my God.
These are the exhibits that are not going back to the jury, but they're part of the record.
You can go on this one over here. Thanks.
All right.
You know, did you remove that text message out of there that was not going back to, you got it up there?
All here,
Okay.
okay? If it was 30,
36 or 35, one of them.
they're all the ones that I'm doing that are right next to that right there. You
Okay.
should have them before they go back.
Okay, I was,
No, that's fine.
All right. Anything else on behalf of the defense at this time?
Just, Your Honor, we'd like to renew our motion for directed verdict, similar to after the plaintiff's case in chief. Now that all the testimony is in, the plaintiff has not met her burden of proof with respect to any of the elements for breach of contract or for fraudulent concealment or fraudulent misrepresentation. We would move for directed verdict in that regard. And we would further include the directed verdict on the punitive damage count because there is absolutely no evidence of malice or any action on the part of my client that rises to the standard of, that would warrant punitive damages, and certainly no evidence by clear and convincing evidence of that amount, or that type of conduct.
Well, when the court views all the evidence in the light most favorable to the non-moving party, in this case the plaintiff, court finds that there is sufficient evidence for this case to go to the jury. I'm going to overrule that motion at this time. Anything else for the defense before we talk about jury instructions?
No, Your Honor.
Mr. Sternberg, anything aside from jury instructions you want to discuss?
no, Your Honor.
All right, so let's talk about jury instructions. I provided a draft of the instructions to both sides. We start with the plaintiff. Any corrections, changes, modifications, additions, typos you found? Anything that you want to discuss?
No, Your Honor, I have not found any typos or any corrections I
You're
would have made.
satisfied with the instructions that
I am
provided?
satisfied with the instructions.
For the defense?
I object to the instruction on punitive damages being sent to the jury, and if, I understand the judge's ruling on the directed verdict, if punitive damage instructions are going to be given to the jury, I would move that the instructions and the procedures be followed under ORC section 2315.21. Other than that, I don't have any
What
other.
procedure are you talking about? The one that you should, the motion to bifurcate should have been filed?
Yes.
And that's way too late for that. We already talked about it with the jury. The whole point of that is that the jury doesn't hear about that. We discussed that in chambers before we even started. And that request was never made, so that's overruled.
Thank you, Your Honor. The only other comment I would make, and I hate to help Mr. Sternberg out, but I don't see that there's a line, maybe I'm missing this. Oh wait, I am missing it, so I apologize. So there is a line for compensatory damages. Okay, I missed it. In the,
Oh, the verdict form?
Yeah, the
That's
verdict
what I was
form.
going to next. You guys have seen that.
Oh, I'm sorry, go ahead and ask Mr. Sternberg.
Let me get to that.
I would compliment whoever drafted the verdict forms in that they are streamlined in a way I don't usually see, and so streamlined
That's what I
that
was doing the whole time up here.
oh,
I really was.
they're so streamlined that I actually missed part of it. So
See, they don't believe me. They do all my jury instructions. Amy helped out beforehand. She did a draft last week. All right, where am I at? Verdict form. For the plaintiff, Mr. Sternberg, you're good with the verdict form?
I am good with the
Has a
verdict.
place for compensatory for the breach of contract and for the fraud. Yeah, good. Okay. All right, then here's what I want to do. I'm going to bring the jurors out here. Well, Just start, well, it's only 15 minutes now. I was gonna start the jury instructions and read the first part, then break, but I thought that would've been 20 minutes ago. We'll just break now and come back at a quarter till.
Quarter to
One.
1, okay.
Let's take it now. Anything else we need to address then?
No thanks.
All right, Stan, go get the jury. Put my robot.
Yes, sir. All rise. No, you didn't. Sit down.
It's like being in church, up, down, up, down.
Peace be with you. He's a character. Adds a little levity to this room.
All rise for the jury. All rise. You may be seated.
All right, ladies and gentlemen, we are all set to continue on here. What we're gonna do though, we'll break for lunch now, because closing numbers is gonna take some decent amount of time. We'll come back in an hour exactly, so we'll start back up at 12:45. 12:45, some of you are looking like I was reading the clock wrong. And then we'll start with the jury instructions and closing arguments, and then we'll be done. Please do not talk about this case amongst yourselves, anything having to do with the case. No investigating, researching any issues. Again, let's take an hour for lunch, and we'll start back up at 12:45 and with the jury instructions. So enjoy your lunch.
All rise.
begin your deliberations. The next step is that I am going to provide you with the instructions, final instructions of law. The parties will then make closing arguments, and then I'll have some concluding instructions for you before you get to begin your deliberations. Now, in regard to these instructions, I am required to read those to you at this time. What did I just do? I'm required to read them to you. I'm going to put them up on the big screen. You can read along with me if you want. I'm not expecting you to memorize what I'm telling you. You're going to get multiple copies of these, written copies of these back in the jury room with you, so you have them with you when you're deliberating. But I am required to read them to you first, so we are going to do that at this time. Let me. All right. So let's get started. Let me get it up there. Members of the jury, you have heard the evidence and the arguments of counsel. It is not the duty of the court to now instruct you on the law which applies to this case. The court and jury have separate functions. You decide the disputed facts, and I give the instructions of law. It is your sworn duty to accept these instructions and to apply the law as it is given to you. You are not permitted to change the law nor to apply your own idea of what you think the law should be. You see some spots with like blue lines under the word. That's because the computer's trying to tell me I'm wrong and I disagree, so I left it there. But that's all that is. So don't emphasize those. Those words are not being emphasized for any reason. The party that claims that certain facts exist must prove them by preponderance of the evidence. This duty is known as the burden of proof. In this case, the burden of proof is upon the plaintiff to prove the facts necessary for her case. It should be by preponderance of the evidence. Later the court will outline and explain the factual issues. Preponderance of the evidence is the greater weight of the evidence. That is, evidence that you believe because it outweighs in your mind the evidence opposed to it. A preponderance means evidence that is more probable, more persuasive, or of greater probative value. You must weigh the quality of the evidence. Quality may or may not be identical with quantity or the greater number of witnesses. In determining whether an issue has been proved by preponderance of the evidence, you should consider all of the evidence, regardless of who produced it. If the weight of the evidence is equally balanced, the party who has the burden of proof, in this case the plaintiff, has not established such issue by preponderance of the evidence. The evidence in this case includes all the testimony received from the witnesses, the exhibits admitted during the trial, any facts that may be agreed to by counsel, and any facts that the court requires you to accept as true. Evidence may be direct or circumstantial, or it could be both. You must decide from all the direct and circumstantial evidence taken together whether the party who has the burden of proof has met the burden. Direct evidence is the testimony given by a witness who has seen or heard the facts to which that witness testifies. It includes exhibits admitted to evidence during the trial. Circumstantial evidence is the proof of facts or circumstances by direct evidence from which you may reasonably infer other related or connected facts which naturally and logically follow according to the common experience of mankind. Now, as an example, if you awake in the morning and see the ground is covered in snow, that is circumstantial evidence that it snowed earlier. Likewise, if you see human footprints in sand, that is circumstantial evidence that someone had previously walked there. Direct evidence and circumstantial evidence are of equal weight. Now, to infer, to make an inference, is to reach a reasonable conclusion or deduction of fact which you may but are not required to make from other facts which you find have been established by direct evidence. You may infer a fact or facts or reach a reasonable conclusion about a fact or facts only from other facts and or circumstances that have been proved by the greater weight of the evidence. You may not, however, infer or reach a conclusion about a fact or facts from a speculative or remote basis that has not been established by the greater weight of the evidence. Further, you may not build one inference on another inference, but you may make more than one inference from the same facts or circumstances. Whether an inference is made rests entirely with you. Now, exhibits and testimony related to them have been introduced. You will determine what weight, if any, the exhibits should receive in light of all the evidence. If there's a copy of an exhibit, you should consider it the same as an original. If there are deletions or redactions, you must not consider those parts. The exhibits are identified by their numbers or letters. The fact that numbers or letters may be missing or omitted from the normal sequence shall not be considered by you for any reason. The evidence does not include the pleadings, any questions by counsel that contain assertions of fact, or any statements of counsel made during the trial unless such statements were an admission or agreement admitting certain facts. The opening statements and closing arguments of counsel are designed to assist you. They are not evidence. Statements or answers that were ordered stricken or to which the court sustained an objection or which you were instructed to disregard are not evidence and must be treated as though you never heard them. You must not guess why the court sustained the objection to any question or what the answer to such question might have been. You must not consider as evidence any suggestion included in a question that was not answered. Now, as jurors, you are the judges of the facts, the believability of the witnesses, and the weight of the evidence. To weigh the evidence or determine the greater weight of the evidence, you must consider the believability of the witnesses. You will use the test of truthfulness, which you will use in your daily lives. And these tests include the appearance of each witness upon the stand, the manner of testifying, the reasonableness of the testimony, the opportunity the witness had to see, hear, and know the things concerning which that witness testified, accuracy of memory, frankness or lack of it, intelligence, interest, and bias, if any, together with all the facts and circumstances surrounding that testimony. Use these tests and assign to each witness's testimony such weight as you think proper. You are not required to believe the testimony of any witness simply because that person was under oath. You may believe or disbelieve all or any part of the testimony of any witness. It is your duty to determine what testimony to believe and what testimony not to believe. You should not decide any issue of fact merely on the basis of the number of witnesses who testify on each side. Each side of an issue. Each side of an issue. Rather, the final test in judging evidence will be the force and weight of the evidence, regardless of the number of witnesses on each side of an issue. The testimony of one witness believed by you is sufficient to prove any fact. Normally, a witness may not express an opinion. However, a person who had an opportunity to observe is permitted to express an opinion as to any issue of fact he or she perceived. In determining the value of such opinions, you shall consider the opportunity that such witness had to observe the facts and his or her knowledge of and experience with those facts. In addition, you will apply the usual rules for testing believability and determining the weight to be given to the testimony. In addition, while a witness normally may not express an opinion, one who follows a profession or a special line of work may express his or her opinion because of his or her education, knowledge, and experience. Such testimony is admitted for whatever assistance it may provide to help you to arrive at a just verdict. Questions may have been asked in which an expert witness was permitted to assume that certain facts were true and to give an opinion based on that assumption. You must decide whether the assumed facts on which the expert based an opinion are true. If any assumed fact was not established by the greater weight of the evidence, you will decide the effect of that failure on the value of the opinion of the expert. Questions may have also been asked of an expert witness after the disclosure of the underlying facts or data. It is for you, the jury, to decide if such facts or data on which the expert based his or her opinion are true, and you will decide the weight to give such evidence. As with other witnesses, on you alone rests the duty of deciding what weight to give to the testimony of the experts. In deciding its weight, consider the skill, experience, knowledge, veracity, familiarity with the facts of the case, and the usual rules for testing credibility or believability and deciding the weight to give to the testimony. All right, now as for the specific issues in this case. The plaintiff, Don Canez, has asserted 3 claims in this action against the defendant, Nicholas Zevnik: breach of contract, fraudulent misrepresentation, and fraudulent concealment. Breach of contract. Plaintiff claims the defendant entered into a contract with her for the purchase of property and that defendant breached the contract, causing plaintiff damages. Before you can find for the plaintiff on this claim, you must find by the greater weight of the evidence that 1, the parties entered into a contract, and 2, the defendant breached the contract by misrepresenting or failing to disclose material defects associated with the property and failing to deliver the property to plaintiff and the condition agreed to in the agreement. And 3, the plaintiff had substantially performed her duties under the contract at the time of the defendant's breach. Now, a contract is an agreement or an obligation, whether verbal or written, in which one party becomes obligated to another to pay a sum of money or to perform or omit to do certain act or acts. It is not necessary that the parties use any particular words, perform any particular acts, or use any particular form of agreement in order to create a contract. In order to form a contract, the parties must mutually consent to the agreement or obligation undertaken by them. Mutual consent arises out of the intent of the parties as shown by the reasonable meaning of their words and conduct, and not from any unexpressed intention or understanding by their party. In deciding whether there was a mutual consent, you should consider not only the words and conduct of the parties, but also the circumstances under which the words were used and the conduct occurred. A contract is breached when one party fails or refuses to perform his or her duties under the contract. Substantial performance by plaintiff means the absence of a breach that violates a term essential to the purpose of the contract. Substantial performance may include mere nominal, trifling, slight, or technical departures from the contract terms, so long as plaintiff acts in good faith. Good faith means honesty in fact in the conduct or transaction. Now, if you find by the greater weight of the evidence that plaintiff proved her claim, then you must further decide whether the defendant's breach caused plaintiff to suffer any damages, and if so, in what amount. If you find by the greater weight of the evidence that plaintiff failed to prove any part of her claim, then you will find for the defendant. Cause, proximate or direct cause, is an act or failure to act that in a natural and continuous sequence directly produces the damages, and without which the damages would not have occurred. Damages for breach of contract. If you find by the greater weight of the evidence that the defendant breached the contract, the plaintiff is entitled to damages in the amount sufficient to place her in the same position in which she would have been if the contract had been fully performed by the defendant, to the extent that the damages are reasonably certain and reasonably foreseeable. You may only award damages the existence and amount of which are reasonably certain and have been proved to you by the greater weight of the evidence. You may not award damages that are remote or speculative. Further, you may only award those damages that were the natural and probable result of the breach of the contract, or that were reasonably within the contemplation of the parties as the probable result of the breach of contract. This does not require the defendant actually be aware of damages that will result from the breach of the contract, so long as the damages are reasonably foreseeable at the time the parties entered into the contract as a probable result of the breach. Now, the defendant claims the plaintiff failed to mitigate her damages. If the defendant proves by the greater weight of the evidence that the plaintiff did not use reasonable diligence or make reasonable efforts under the facts and circumstances and evidence to avoid loss or decrease damages caused by the defendant's breach of the contract, you should not allow damages that could have been avoided by the exercise of reasonable diligence or reasonable efforts to avoid loss. The plaintiff, however, is not required to take measures that would involve undue risk, burden, or humiliation. Now, as for the fraud counts, misrepresentation, and fraudulent concealment, plaintiff claims the defendant committed certain fraudulent acts against her which plaintiff relied upon to her damage. Specifically, plaintiff claims that the defendant knowingly made false representations and intentionally concealed the water problems, mold, and flooding, among other problems in the home and upon the property. The defendant denies he had any knowledge of the defects with the property. Fraud is a civil wrong. It's a deception practiced with a view to gaining an unlawful or unfair advantage. Fraud is a false representation of fact, whether by words, conduct, or concealment, which misleads and is intended to mislead another so that he or she relies on it to his or her injury. Before you can find for the plaintiff, you must find by the greater weight of the evidence that the defendant represented a fact or concealed a fact that he had a duty to disclose, and 2, that the fact was material to the transaction at hand, and 3, the defendant represented that fact knowing it was false or represented that fact with utter disregard and recklessness as to the truth or falsity of that fact, so that the defendant's knowledge of the falsity may be inferred or the defendant concealed a known fact. Four, the defendant intended to mislead the plaintiff into relying upon the fact as presented. And 5, the plaintiff justifiably relied upon the fact as presented. And 6, the damage was proximately or directly caused by the reliance upon the fact as presented. Now, material representation or concealment must be definite and important, necessary and or influential to the transaction. It must be so substantial and important that it influenced the person to whom it was made or from whom it was concealed. The representation or concealment must be based on a present or past fact. A representation is false when it is not substantially true. The truth or falsity of a representation depends on the natural and obvious meanings of the words taking into consideration all the surrounding facts and circumstances and evidence. Knowledge means that the defendant is aware of the existence of the fact and that his acts will probably cause a certain result or be of a certain nature. The defendant acts with knowledge when he is aware that his representation or concealment will probably cause a certain result or probably be of a certain nature. Because you cannot look into the mind of another, knowledge is determined from all the facts and circumstances and evidence. Reckless. A representation or omission is reckless when the person who makes the representation or omission is totally or completely careless or indifferent to the consequences or the risks that the representation or omission will cause the person to whom it is made to do or not to do certain things. If a person had no knowledge of a fact but asserted the fact as true when false, you may find that he made the representation with utter disregard and recklessness. A representation recklessly made without knowledge of the truth is the same as a false representation knowingly made. Intent to mislead. The defendant's intent is known only to himself unless he expresses it to others or indicates it by his conduct. Intent is determined from the way in which the representation is made or the facts are concealed, the means used, and all the facts and circumstances and evidence. Justifiable reliance exists when a representation or concealment of facts was made, when a person of ordinary care would rely on it under the same or similar circumstances to his detriment. In determining whether reliance is justifiable, you may consider the nature of the transaction, the form and materiality of the representation, the relationship of the parties, the respective intelligence, experience, age, and mental physical condition of the parties, and the respective knowledge and means of knowledge. Expressions of opinion, even though false, are not a basis for fraud. If you find the plaintiff proved by the greater weight of the evidence each of the elements of fraudulent concealment or fraudulent misrepresentation, you will find in favor of the plaintiff. On the other hand, you will find in favor of the defendant if you find the plaintiff failed to prove any of these elements of fraudulent concealment or fraudulent misrepresentation by the greater weight of the evidence. Now, for the defense of caveat emptor, the defendant claims that his conduct was not fraudulent, that the defect could have been seen or discovered, and that the defendant did nothing to interfere with the plaintiff's opportunity to inspect the house. This is called an affirmative defense. The burden of proving an affirmative defense by preponderance of the evidence is on the defendant. To find for the defendant, you must find by the greater weight of the evidence the following. 1, the defendant did not conceal a structural defect in the house or a condition of the house, or did not misrepresent a structural defect in the house or condition of the house, or did not fail to disclose a material fact relating to a structural defect in the house or condition of the house not readily observable or discoverable upon reasonable inspection, or 2, the concealment was not made with knowledge of the condition or with such utter disregard and recklessness that knowledge may be inferred, or the representation was not made with knowledge of its falsity or with such utter disregard and recklessness that knowledge may be inferred. I may have repeated that. Or the failure to disclose was not made with knowledge of the condition not disclosed or with such utter disregard and recklessness that knowledge may be inferred. Knowledge means the defendant was aware of the existence of the material fact. The defendant acted with knowledge if he was aware that his misrepresentation would probably cause the plaintiff to purchase her home when she otherwise would not have done so. Since you cannot look into the mind of another, knowledge is determined from all the facts and circumstances in evidence. Duty to disclose. The law requires that a seller of a residential home disclose patent or latent defects that were within the seller's actual knowledge and complete a residential property disclosure form, referred to as an RPDF, in good faith. If the plaintiff had the opportunity to inspect the property, she is charged with the knowledge of conditions that a reasonable inspection would disclose, unless the defendant made specific representations about a material fact, or when the defects are not open and could not have been discovered on reasonable inspection. The defendant was not required to inspect his property or acquire knowledge regarding the defects. The plaintiff had a duty to complete a full inspection, and the RPDF is not a substitute for her careful inspection. The as-is clause in the RFDF, it should be RPDF, relieves the defendant of the duty to disclose latent defects and precludes a claim against him based on, quote, passive non-disclosure. Latent defects are those imperfections that are hidden or not discoverable by reasonable inspection. Failure to investigate. The defendant claims that the plaintiff had a duty to investigate and was not justified in relying on the representation or failure to disclose. When a person had the opportunity to inspect, and when the circumstances would have caused a person of ordinary care to inspect and she failed to do so, the element of justifiable reliance has not been proven and the plaintiff cannot recover. If the plaintiff investigated the facts, concealed, represented, or not disclosed, and relied on this investigation and did not rely on facts concealed, represented, or not disclosed, then the plaintiff is not entitled to recover. If representations were made by the defendant with an intention to deceive or mislead the plaintiff, causing her to fail to make or refrain from making an inspection or inquiry, which in the use of ordinary care she would have made, there is no duty to inspect or inquire, and the plaintiff may justifiably rely on the defendant's representations. Fix that there. The doctrine of caveat emptor does not apply when specific representations about a material fact are made by the seller or when the defects are not open and could not have been discovered on reasonable inspection. The doctrine of caveat emptor will defeat a claim of fraudulent concealment if the residence is sold as is, with the buyer having a 14-day inspection period, and if the observable and discoverable conditions would put a reasonable person on notice of a possible defect. Now, the plaintiff must be directly damaged by the reliance on the representation or concealment. This means that the damage was caused by the representation or concealment in a natural and continuous sequence, and without which the damage would not have occurred. Proximate or direct cause is an act or failure to act that in the natural and continuous sequence directly produced the damages, and without which the damages would not have occurred. If you find that the plaintiff has proved by the greater weight of the evidence all the elements of fraud, your verdict must be for the plaintiff, and you will then consider damages. However, if you find that the plaintiff has failed to prove by the greater weight of the evidence any one or more of the elements of fraud, or if you're unable to determine what happened, your verdict must be for the defendant. And if damages for fraud, if you find for the plaintiff, you will decide from the greater weight of the evidence what amount of money will reasonably compensate her for the actual damage directly caused by the fraud. The measure of damages in this case is the difference between the represented value and the actual value at the time of the transaction. If you find the plaintiff is entitled to compensatory damages against the defendant for fraud, you must then consider whether you will separately award punitive damages. Punitive damages may be awarded against the defendant as a punishment and to discourage others from committing similar wrongful acts. You are not required to award punitive damages to plaintiff, and you may not do so unless you find the plaintiff has met her burden to prove by clear and convincing evidence that 1. Defendant's actions demonstrated actual malice, or 2. Defendant's actions demonstrated aggravated or egregious fraud. Actual malice is defined or is necessary for an award of punitive damages, and it is defined as a conscious disregard for the rights and safety of another person that has a great probability of causing substantial harm. Substantial means major or significant and not trifling or small. Aggravated or egregious fraud. Fraud is aggravated if it is accompanied by the existence of malice or ill will. Fraud is egregious if the fraudulent wrongdoing is particularly gross or malicious. Clear and convincing means that the evidence must produce in your minds a firm belief or conviction about the facts to be proved or the truth of the matter. It must be more than evidence that simply outweighs or overbalances evidence opposed to it. Punitive damages are not automatically awarded in cases where a defendant is found liable. If you award punitive damages, the amount should be fair and reasonable under all the facts and circumstances. It should not be excessive nor influenced by passion, sympathy, or prejudice. If you award punitive damages, it should be presumed that the plaintiff has been made whole for her injuries by the award of compensatory damages, and determine the amount of punitive damages. You may consider all of the following. The harm caused was physical as opposed to economic. The tortious conduct evinced an indifference or a reckless disregard of the health or safety of others. The target of the conduct had financial vulnerability. The conduct involved repeated actions or was an isolated incident. And 3, the harm was a result. 5, the harm was a result of intentional malice, trickery, or deceit, or mere accident. The amount you award should be fair and reasonable and should not be influenced by passion or prejudice. Attorney's fees. If you decide that the defendant is liable for punitive damages, you must also decide whether the defendant is liable for the reasonable attorney fees of counsel employed by the plaintiff in the prosecution of this action. If you decide that the defendant is liable for attorney fees, the court will determine the amount. All right. So at this point now we're going to proceed with closing arguments, and then after closing arguments I will give you some concluding instructions. Now, for closing arguments, let me remind you that what the attorneys say is not evidence. But closing arguments are an opportunity for each side to summarize for you what they believe the evidence in the case is established. The plaintiff, having the burden of proof, gets the opportunity to go first. The defense then gets an opportunity to make closing argument. And the plaintiff, because they do have the burden, gets the opportunity then to make a rebuttal argument. So Mr. Sternberg for the plaintiff.
Thank you, Your Honor.
You want that on?
Yeah. Ladies and gentlemen of the jury, it's been a long 2.5 days. Your role now is to decide the facts in this case. As you have heard, this case has been going on for a while. Don Kinez made her complaints about the property known in October of 2021, wrote a letter in December of 2021, and had her attorney send a letter to the defendant in April of 2022. The evidence is clear that Ms. Kinez and the defendant entered into a contract to purchase the property at 30208 Oakdale Road. You've seen Exhibit 1, which is the purchase agreement. You've also seen the addendum, which removes the result of an inspection. You have heard that the house was inspected, and you can infer from the evidence of the inspection, from the testimony of the concern by Don regarding water infiltration, drainage problems, because based on her experience in another home, that any report that would have indicated anything regarding these problems would have kept her from entering into this contract. She's testified that she's had that discussion when she saw the home on August 2nd of 2021 and met the defendant as they were leaving. She asked him about those problems specifically. You had her uncle, who was present for it, also testify. You also have the defendant admit it. Now, on the stand of his own recollection, testifying today, he didn't recall the exact conversation she asked, the questions. But you'll notice in his affidavit, which has been made in this exhibit, I believe Exhibit 41, he stated that he agreed in that affidavit that she had asked about these problems. And as he did understand, he testified that he told her that there were no problems and he would have told her the problems. We have the evidence of, upon moving into the home, of the flooding of the backyard. Now, you've heard discussion regarding whether this is significant or not. You have the picture of February Plaintiff's Exhibit 16, which was taken by Dawn with her son standing there. You also have the earlier picture
plaintiff's exhibit 15. And plaintiff's exhibit 12, which was taken in the winter. You also have the video of her son walking through the backyard near the fence. And you'll notice when you look at these videos
Come through the grass, because it's just as squishy,
that
please.
you won't see water draining from the side properties. You will see water coming on from the back property. And you've had the testimony of Mrs. White, who lives next door at 30212 Oakdale Road, which is just directly east of this property. And she can observe the backyard of Don and Mr. Zevnik when he lived there, and observed on numerous occasions the ponding of water. Now, you will determine whether that's significant or not, but you did hear Mr. Courtney, the engineer, claim that if he was buying the house, he would want to know about it, just from what he saw. Let's talk about Mr. Courtney. Mr. Courtney, for whatever reason the defendant had, never saw the property until 14 months after the last work was done on it. By the time he examined the property, the yard had been drained, waterproofing had taken place, the garage tiles were put in so the garage didn't flood from the back and the side. And on 2 occasions there was mold remediation, and the basement had been painted. All done before he ever looked at the property. So what did he base his exam on? Excuse me. He based it on the complaint and the answer. He looked at Ed Reed's ER concrete report. He looked at Lake Geauga Geographic Information System, various mappings. It was interesting, none of the mappings showed anything during a wet season. All of them were dry, nor during a snow season. He looked at the mold tester inspection report and remediation report. He saw that permits were pulled by the city of Willowick, pulled by the contractor with the city of Willowick, and that he knew, as he testified, and as the contractor testified, and as Todd Shannon said he wouldn't have been the one to do the inspection, but all the work had been inspected by the city of Willowick and approved. He also looked at Zevnik's homeowner's insurance loss history. I believe it was Mr. Schubert who testified on behalf of State Farm. And if you recall, he said there was no report of any losses. And when asked if any of the water problems that Mrs. Miskinez is complaining of, would they have been covered under the policy? He said no. If it's not covered under the policy, they won't have a loss history. It seems that Mr. Courtney's biggest issue is with how the city of Willowick allows people to tie in their storm drains. He disapproves of being tied in to the downspout drains. You have both the defendant's contractor when he put in the driveway, and Mr. Reed when he remediated the water, tied in to what was approved by the city of Willowick. The interesting thing is, after the work was done testified, Mr. Reed, there weren't any water problems in the basement or the yard. Now, there's some discussion as to when water started seeping into the basement. If you recall Mr. Reed's testimony, he noticed it when he was at the house in February of 2022. That was before he did any work in the yard. So obviously, from his testimony, these water problems had persisted before. Now, Ms. Knez testified that the colors used in the basement were the same colors that she found on the paint cans that was purchased in July of 2020. And we do contend that the basement was painted prior to in 2020. And we contend that because, as she said, she could see the colors, they match, and there was no visible water problems when she toured the house on August 2nd of 2021. We also know that there were water intrusions in the house. We know that from the text messages between the neighbor and Mrs. Zebner, where Mrs. White says, "Hey, not sure if either of you are at home, but our house and 3 others on the street we know flooded." And she gets a response from Mrs. Zebner, "Ours is flooding too." "Oh no." We have WTF. Is it bad? Rug is soaked, and there's a bunch of places it's coming from. Now, you recall from the testimony, I think both Mrs. The realtor, Mrs. Pete, the realtor, and the testimony regarding the basement, that rug was in the finished side of the basement. That rug was between the 2 couches that were down there. And she goes, "The rug is soaked, and there's a bunch of places it's coming from." "Oh no, I'm sorry." LOL, same mirror for you. And it goes on, "Randy patched it up, and I got the water cleaned up, just waiting to hear from the company to come replace this broken cement block window. Adulting sucks. The garage is flooded." Now that's Mrs. White. And you get from Mrs. Zebner, "Our garage is the same way. Now it's like oozing through the tiles. There's no actual holes to patch." Again, that's in the finished part of the basement. From that, we know that the basement on the finish end had water problems in August of 2019. 2 years before this was sold, and a year before the paint was purchased in July of 2020. Now, the defendant wants you to believe that after this happened, his wife didn't tell him about it. Now, common sense and knowledge of marriages would not support such a finding. One would expect that a wife would tell her husband after water came through the tiles in the basement. From the beginning, Ms. Knez made it known that these were important issues for her. The defendant admitted he knew that on the stand from his affidavit. The defendant in the residential dwelling disclosure form numerous questions you'll be able to read regarding drainage, water seeping into crawl space, sewers, the whole thing. And in each question he answered, no, there were no problems. Yet we know a year, 2 years before this, he had water seeping in the basement. We know from the neighbor that they both had constantly ponding in their yards. There's a lot of testimony about dye testing. And the conclusion from each of the witnesses who testified to dye testing was that dye testing doesn't tell you whether you have water seeping into the basement. What it tells you is whether your storm sewers are infiltrating the sanitary sewers. And the reason for that, obviously, they don't want the sanitary sewers to carry more water and not to be treated. So that really didn't answer the question of not knowing whether or not the basement was taking that water. As to the blocked line in the basement, the evidence was from Mr. Hudak. He was there when the tub was broken up, slop sleep, and carried in and broken up in the tub. The floor had been covered. There was no damage to the floor. When we snaked out the televised that drain, it showed there was a blockage in it. And to remove that blockage, they had to crack open the floor, put in a new pipe, and re-cement. Also, Mr. Pizak testified that Ms. Ganes never asked her about any water problems. When we called her on cross, she testified she never met Ms. Ganes and never talked to Ms. Ganes. So obviously, Ms. Ganes could not have expressed her concerns to her, nor was she at the house when the house was observed. The cost of repairs and you will have each of the receipts have testified to. The cost for Mr. Reuter to televise the line, to replace the pipe that was crushed underneath was $3,910.06. Then you have the work of ER concrete and sewer, the yard drain, the waterproofing of the east wall, and then the front waterproofing and correcting the drain to the laterals. Total of $28,600. Mold testers, the initial test, the 2 remediations, and then another test to make sure the property was mold-free, $5,501. Orange lawn care. You'll recall the pictures. The house was very nicely landscaped. However, that landscaping had to be destroyed to do the waterproofing. And the cost of the landscaping was $7,503.85. And then Blue Line was the paint company and the drywall company. You recall that Mr. Nichols testified in order to do the mold remediation, he had to cut out 14 inches from the floor and remove that drywall. You also recall that he said from observing the drywall that had the mold, it appeared that the drywall had been put on a wet wall because of the nature of the growth pattern. It seems to indicate somebody else had a water problem and tried to fix it.
those costs for the Blue Line Paint Company to paint the basement and to do the drywall was $5,250. Total damages were $50,764.91. Definitely a breach of contract, breaching what the representations were on the residential statement form and on the statements made. Ms. Kness did everything possible. She had the house inspected, and because of the concealment by the freshly painted basement and the tile, and you recall the tile, and you'll see the picture of the tile, where the carpet was underneath the carpet, the tiles were of a different shade. You'll notice that, which would indicate at some time or another they had been replaced and was a problem. That too was also noticed by Mr. Reed when he saw the house. We think all these evidence of a fraud, that is, the defendant knew that the basement had a water problem. The defendant knew his back lot flooded, and he didn't disclose it. In fact, he misrepresented it. In fact, he took steps to conceal inside the house that there had been problems. Based on that evidence, we're going to ask you to find was a breach of contract. We're going to ask you that the greater weight of the evidence shows that there was a fraud of active concealment by the defendant, and that the damages from the misrepresentation and the concealment and the breach of contract total for $50,764.94. And only by incurring those expenses could she correct the breach of contract and resolve the damages in the house. We're going to ask you for punitive damages. We believe it's outrageous that somebody would lie, consistently lie, regarding these facts and misrepresent the nature of the property. We believe that the evidence shows, by clear and convincing, that which would make the most important decisions of your life, that this was a aggravated fraud in the way it was done. And we would ask you to award punitive damages, and the amount of punitive damages we would leave to you to decide on how much you think an individual should be punished for the conduct of this. Thank you.
Thank you. Mr. Grove, any further comments?
Thank you, Your Honor.
You don't want your computer?
I'm sorry?
You don't want your computer?
No. Ladies and gentlemen, I'd like to thank you for your patience and your attention that you gave to this case over the past few days. I know my client appreciates it, I appreciate it. It is your patience and attention to the details and the evidence of this case that I think is going to result in the right verdict in this case. I told you at the beginning that this was a serious case, and you just found out why. I told you that I was going to have to ask hard questions in this case, and I was not. Sometimes I wasn't going to be nice, and I have a tendency to be like a thoroughbred horse that kicks open his barn door once in a while, and I have tried the patience of the judge in this case from time to time, and to the extent that distracted you or delayed this case in any way, I apologize. However, these questions need to be asked, and this evidence needs to come out. And I asked you at the beginning of this case that if the evidence shows that my client is entitled to a defense verdict, each and every one of you indicated that you were able to do that. You were capable of rendering a defense verdict, and I'm going to ask you that after my comments here today. Now, it's a difficult position to be a defendant, but it's even a more difficult position to be in when you're asked to prove the negative. So I'm here not to prove that somebody acted or somebody did something. I have to prove that somebody didn't do something. Somebody didn't represent a fact, and somebody was not aware of a water or sewage or sewer problems on the property because there were no such problems. And the plaintiff has not proven that those problems existed, or that my client knew about them, or that my client intentionally misled Ms. Inez about it. They did not prove that. They have not sustained their burden of proof. They put up suggestions as to why you should think that. They put up circumstantial evidence that might lead you to the conclusion that my client, well, first of all, that there was and is a problem with water on the property, that my client knew about it. But every time you ask the next question about each item, when you ask the next question, you find that there is no evidence. There is no basis to suggest there's a problem on the property that my client knew about it. And let me give you some examples. The issue that Mr. Sternberg talked about in his closing, the paint cans in the basement. Paint cans in the basement, and I'm sorry, Your Honor, can we get access? 31. Mr. Sternberg argues that my client must have known that there's water staying in the basement because they found paint in the basement.
Hang on one second, I don't know what stuff going on. I've got it turned on there.
Is it connected?
Well, maybe it's here, Stan. Oh, hang on.
No, it's coming from here. I mean, it should show up there.
Yeah.
Was that you? No.
That was me. I just wanted to see if it connected.
Yes,
so
sir. It's saying it's connected, but
something in the connection here.
it's got to be right or something.
Hey, we know what the paint can say.
No,
That's okay, that's fine. Try to keep working on it, but we'll. That leads me to another conclusion. I've tried a number of cases in my career, and inevitably, after the case is over and I get to talk to the jurors, they say,
Strawberry, it's up there now.
oh, good. You saw it. Inevitably, the jurors will say, you know, we got it about an hour ago. You didn't have to keep bringing it on. So to that extent, I apologize. In any event, paint cans in the basement is evidence of my client concealing water stains until you ask the next question. And the next question is answered. He contracted with a painter to paint upstairs, and he left the cans there for somebody else to use later on if there's a touch-up. To me, isn't that uncommon? You see that in every household, in a house that's sold to another person. Replace tile, I'm not going to ask you to look at the tile. Maybe my client replaced tile as a result of water damage. No, never once did it. Lori Petersak left that in the garage, again, in case somebody needed it. No one ever did. When I asked Ms. Kinez about these items, she said, well, someone could speculate that that's what you did, but that's exactly what you're not allowed to do in this case, because Judge Culotta just read to you, you may not infer or reach a conclusion about facts from a speculative or remote basis. You can't do it. So every time you ask the next question, the case falls apart. Mold in the basement. They claim there was mold in the basement. There was tests done in February of 2022, before any of this work was done in the basement, before it was re-waterproof, before the yard drained in. And then we had to do remediation until you asked the next question. And the next question was, Mr. Nichols, were those rates of bacteria in the basement within normal limits? And he said, yeah. More than normal. Perfectly normal. Expected. That's what you expect to find. That's not evidence of water in the basement. That can't show that my client concealed something. So I also said at the beginning of this case that there are certain organic or certain organic or basic reasons why Ms. Kinez cannot be correct about my client's motivations in this case. First, when they had that conversation in the driveway, she had not even made an offer yet. He had no idea whether she was going to make an offer that would be acceptable. So what reason would he have to try to dupe her or lie to her about the condition of the property, especially when he had 3 other offers already on the table. Already on the table for asking one all-cash deal with waiving of all contingencies. What in the world would he need to do, ask Ms. Knez or lie to Ms. Knez about it? He didn't know what her offer was going to be, what it was going to be at or above asking. There was just no reason to do it. And he got nowhere. Every time an example is pointed to as a possible evidence or inference that water existed in the basement, when you ask the next question, it goes away. Mr. Courtney testified that he inspected the basement. He's an engineer. He inspected the basement, and it's his job to detect sewer problems and water leaking into houses. That's what he does for a living. And he says there's organic ways you can observe a basement to determine whether there's active leaking or whether there was prior leaking. And one of those ways is, and I'm going to mispronounce it again, efflorescence in the basement on the walls. We've seen this. You've seen this in old houses. It will stay on the wall after the water intrusion is rectified. So there's ways you can find out. There are ways that you can prove that somebody had prior knowledge of water intrusion in a basement. You can look at the city records to see if prior owners had called the city and asked for maintenance on the sewers. That's one way you can determine whether there was prior problems with the basement and whether the homeowner knew about it. There are no records of that. Nick never called the city, and neither did Lori Petersak, and that spanned 30 years. 30 years. You can look at insurance records, and you can determine whether insurance claims were made for water damage. There are some types of water damage claims that are covered, like if you lose personal property. Either way, an insurance company is going to have record that you made a claim. They're not going to just have record of claims where there was coverage. If you call up and make a claim where there's coverage off, they're going to have a record of you doing that. That's how they assess how they're going to charge you the premiums. We all know this. This is our life experience. So let's go back to the beginning. I asked, when we started out this case, what would you like to see in terms of what would show you that my client's position on this case is the correct one, that he didn't know about any water problems and he never misrepresented anything. I said, would you like to hear from the prior owner? Most of you said, yes, we'd like to hear from the prior owner. We did. We heard from Lori Petersak, realtor, bought the house in 1983 with her husband, had it waterproofed then, did a lot of work on the house, took pride in that, in doing the work in the house. You could tell just from the way she testified how enthusiastic she was about the condition of the house and how she and her husband treated it. Never any problems ever. She acted as the real estate agent for Nick when he bought the house in 2011. Again, very helpful. She arranged for Larry Karosik to do an inspection of the house, typical general home inspection. He did it. We pointed through, we went through and looked at the type of things you can find when you do a general home inspection. And many of those things that you can observe on a general home inspection would tip you off or indicate there's a possible problem with water in the house. This is 2011, I get it. But back then, he made no observations of staining or wood rot or anything with the drywall or the block walls. And that's the purpose of that. It protects you. You do that to protect yourself. So then Nick moves in, and the evidence is that he lives there and does very little renovation to the house at all. Makes no changes in the basement. Makes no significant renovations of the yard or the house. And never painted the basement when he was there. Never painted it. Never made a claim for insurance issues, and never reported anything to the city, and never even called Lori Petersak in all those 10 years to ask her any questions about water intrusion or anything at all. Do we have the PowerPoint? Let's keep going. All right. Yep, keep going. Okay, so again, the history of the house is 1983 to 2011, and 2011 to 2021, no issues with the basement at all. No issues with the basement. All right, let's move forward. The property disclosure form was signed by Nick. August 2nd, the purchase agreement was signed. Remember, there were 3 offers already on the property. Mr. Hudak testified that they had lost out on 3 other houses they attempted to buy. This was a Hail Mary pass. They were going to try to get this house no matter what they had to pay. They ended up paying more than the asking price, and they closed. Mr. Nick accepted the offer and they closed. Now, we know that they performed a home inspection because Nick had to clear out of the house for that to happen for a couple of hours. The contract allows them to, let's stick with this for a minute. The contract allows them to do a general home inspection, but it really allows them to do any kind of inspection they want. So if Ms. Kinez was as worried as she testified to about these issues with mold and water in the basement, she was fully permitted to make whatever inspection she wanted to make. No one would have impeded her or stopped her to do that. She was entitled to it, and she could have done it. But she did a general home inspection again, and the contract spells out what happens as a result of that inspection. You can terminate the contract. You can terminate the contract. Or you can accept it as is, which is what she did. She accepted the home, and she removed the contingency. She removed the contingency, and the house closed. Okay, let's go next. But we never saw the plaintiff's inspection report, and you never even got an explanation as to why you didn't get that throughout this trial. I really would like to know. Someday I'd like to find out why you didn't get to see that report. What would that report have said? What did that report say? Why didn't they bring it in? If it helped their case, I suspect they would have brought it in. But what I suspect that report said was there was no observable damage from water in the basement, because there were boxes you could check and things you could circle if you did observe those types of things, if the inspector did observe those types of things. So it's my suspicion, and not an unreasonable one, that the reason they didn't introduce that report or tell you why they're not introducing it is that it wasn't helpful for them. In fact, it probably hurt their case. Okay, let's advance. Okay, keep going. All right, now this is where, I think this is where this lawsuit starts. September 13th, closing on the property. October 16th, now remember this, October 16th and 22nd, Mr. Reuter is already out at the property doing work. He's already there. This is after A and Z Plumbing was terminated because there was some problem they had when they were trying to replace the slop sink. And Mrs. Kinez put that in her letter. They did insufficient work on the slop sink and the drain. And that's why she had to bring in Mr. Reuter. But she was texting Nick, let's go on to the text. On the 22nd, this is after Mr. Reuter was out there, after Mr. Reuter was there, texting him and saying, hi, 2 pieces of mail, question, second thing, not the first thing on her mind when she texted him. Can you please tell me the story with water on the floor when the laundry's run? And then Nick says, when this happened, it's because the lint guard on the hose from the washer was full and needed to be changed. Now, there's been no evidence in this case to the contrary, that that's what he experienced. If it ever happened at all to him, it happened when the lint guard needed to be changed. So let's go to Exhibit 5, Plaintiff's Exhibit 5. They introduced this exhibit in an effort to show you or convince you that this is the way Nick left the drain into the storm sewer from the slop sink. Again, that's what they led you to believe until you asked the next question, and that was, Nick never left that drain in that configuration. It was in a completely different configuration. Can we have Exhibit K, I think it is? Yeah, our Exhibit K. This is how, in a similar configuration as this is how it was left. Not how they showed you in their own Exhibit 5. That's not what they did, but they attempted to lead you to believe that in an effort to show that Nick was the cause of water in the basement. All right. Then you heard testimony of, in chronological order, the next thing that happened was they had Reuter come out and do this work, and apparently broken tile was found. But we saw no pictures of broken tile, even though apparently some were taken because Mr. Hudak testified to that. We didn't see that. That wasn't placed in evidence in this case. Let's go back to the PowerPoint. In February of 2022, worried about mold, Mrs. Knez hires Mr. Nichols to come in and do mold testing and mold remediation. His tests show that the mold levels were within normal limits, more than normal, I think his testimony was. All right, let's advance. Let's advance. Let's advance. Okay. So ER Concrete, and you heard the testimony from Mr. Reed. He came in and installed a yard drain at the property. He didn't take the permit out to do that himself. He didn't check the diagram as to what the design was intended to do from the original contractor, but he did it anyway. And that work was completed the week of March 7th. You can see from the photographs. Okay, this work was done during that week. Mrs. Knez's testimony was within 2 weeks of the completion of that work, she noticed water coming into the basement. She was asked that by me, she was asked that by Mr. Sternberg, and she confirmed it. 2 weeks. She even put a date down, March 23rd. That's when she started to notice water in the basement. Let's advance one more. You heard the testimony of Mr. Courtney that indicates that the drain area that was fed into that new yard drain included drainage from the 4 neighbors that surround the property, vastly increasing the water flow that's supposed to be carried through into that drain pipe, into the downspouts of Ms. Knez's home. You may recall, Mr. Reed said, he was asked, could you have directed that directly into the main storm sewer line? He said yes, but it would have cost an extra $4,000. So for an extra $4,000 that Mrs. Knez didn't pay, she could have had this drain properly connected to the storm sewer, and she didn't do it. And he didn't do it. And as you heard from Mr. Courtney, that vastly increases the water flow into the perimeter drains of the house, which put additional stress load on those drains, which more likely than not caused some water to come into the basement. And mind you, Mrs. Knez testified she never noticed water in the basement other than from the slop sink prior to the installation of that yard drain. That's what she testified to. Okay, so I'm going to try to wrap this up as quickly as I can. I'm sure you're hopeful of that. Mr. Courtney testified at length, based on his experience, and this is what he does for a living, that her water problems in the house were caused more likely than not because of this increased load in the drain. He also testified, and can we go to Exhibit A, our photographs, that there is direct, not circumstantial, there is direct evidence that there is no ponding problem in this or the surrounding properties of any substantial basis that would have caused any diminishment of the condition of the home. Why? You can look at the back of the house now. Go ahead and keep going. Keep going. Keep going. There. You see the grass growing. Now we all live in Lake County, so we're all fully experienced with swamp conditions in people's yards. You can't grow grass. You can't grow grass as vibrant as this. And you don't need to be an arborist or a scientist to know that. You can't grow grass like that if you have a chronic drain problem in your yard. And it's not only that. Mr. Courtney testified you can observe from these aerial photographs that not only does Nick not have a chronic drain problem, neither does anybody else surrounding the property. You would see it. Again, we all live in Lake County. Now, in order to prove that they do in fact have a chronic drainage problem in the backyard, they introduced, and can we please have 11 and 12? Play this 11 and 12. said at the beginning, you were gonna be shown photographs, not of Nick's property, but of his neighbors. This photograph is 100% Marissa White's property, and you can tell because that's her white garage. You saw pictures of Nick's garage, we know that's not it. So in order to prove that there's a chronic drainage problem in the backyard, they put this before you, until we ask the next question, and we find out that's not Nick's property. Okay, let's have 12. Okay, one photograph showing melting snow that seems to be ponding in the backyard. Again, we're all from Lake County. We have seen this in all of our yards. This is not unusual. Okay, let's see 15. Now 15, I want to show you 15 and let's see 16. And 16, 15 and 16, and the video. The testimony and the evidence is all three of those were filmed on the same day. 15 shows just the water that is accumulated. 16 shows Mrs. Knez's son, and 17 is the video. Those are all from the same day. The point I'm trying to make is if they are going to present to you evidence that they think there's a chronic water problem or drainage problem in the backyard, why are they, number one, showing you other people's yards that are flooding? Number two, just showing typical melting snow at the beginning of spring or the beginning of thaw? Or three, that condition that happened on one day. One day. She testified this happens every time it rains. Well, why do we only have one day of photographs? We had to ask the next question every time. There is no ponding problem in this property. So that when Nick had the casual conversation with Mrs. Knez and her uncle, and apparently the agent was there as well, she asked, is there water problems on the property? All Nick knows is that his grass grows in the back with no problem. There's no marshes or swamps. He's never had any problems in the basement. There's never been any mildew smell in the basement. There's no efflorescence, probably the fourth wrong way to pronounce that, in the basement. That's what he knows when he's responding to her question. He's not intentionally misleading her. He's not lying to her. This is what he knows. He knows that his grass is growing so much he has to mow it. He mows his own grass. Now, maybe the issue of the fact that Nick is a police officer is of no relevance in this case at all as to the liability and the damage aspects of the case. Maybe it's of no relevance at all. But I said to you earlier, it does show that he knows the consequences of his actions, and has observed those consequences play out badly for people who act unlawfully. You need to at least appreciate that when you're trying to determine what his state of mind was at the time he had that conversation with Mrs. Knez. So I'm going to ask you for a verdict in favor of Mr. Zebnik. I know I've taken too long, but this is important. That's a lot of money, and it's not like we can just hang that on a wall. Somebody's going to have to pay that money that they're demanding. So the verdict forms, which I don't think you should, did you show the verdict forms?
Not yet.
Okay, so should I not?
You can't do it.
Okay. You're going to be shown some verdict forms from Judge Culotta, and the first verdict form is you're going to be asked about the breach of contract claim. The question is going to be, we the jury find the issues in this case as to the claim of breach of contract as follows: for the defendant, Nick Zebnik. I want you to check that box right there. Check that box right there. And then sign where indicated at the bottom. Next is fraudulent misrepresentation. There's a box here. We, the jury, having been through this panel, find for the defendant, Nick Zebnik. That's what I want you to do. Check that box. That's what the evidence shows. And finally, punitive damages, utterly mind-boggling that Mr. Sternberg would allege Mr. Zebnik acted with malice. Fine for Mr. Well, I guess you're not awarding that if you don't find the other liabilities. In any event, there's boxes to check, and I ask you to look closely at the verdict forms. Check the boxes for verdict in favor of defendant Nick Zebnik. We all committed at the beginning of this case, if that's what the evidence shows, that's what your verdict would be. And I really only want your verdict to be about the evidence and the testimony and the witnesses in this case. Thank you for your attention. Thank you for, I apologize for going on too long. I'd like to thank Judge Culotta. I'd like to thank Mary and Stan, who also had to put up with me for these 3 days. Appreciate your time. Mr. Sternberg gets to speak last. I'm just going to say, when Mr. Sternberg is speaking, having listened to me ad nauseum, think to yourself, what would Fogarty say? What would Fogarty say? Well, listen to Mr. Sternberg. What would Fogarty say in response? Thank you very much.
Thank you. Mr. Sternberg. About
We could probably all conclude Mr. Fogarty probably has some Irish in it. He has to get the gap. I'm not going to ask you to check a box because I'm suggesting it, Mr. Fogarty. I'm going to tell you to check the box the evidence leads you to. Now, it's a lot easier to stand up here and pick apart somebody else's case than it is to present your own case. Now, I have to tell you, after seeing the photographs in the backyard, after hearing the testimony of the next door neighbor that they both suffer from these water problems, and after knowing that in August of 2019, water percolated up from his basement floor, if you don't believe he knew he had a water problem, then you're just not going to believe anything. Now, I know you're sick of hearing about the paint cans, but the issue is, those are the same color as the basement. And if the basement was painted, he concealed the condition. As to the testimony about the mold, I disagree with Mr. Fogarty's recollection. The only recollection that's important is yours. That, yes, Mr. Nichols testified as to outside mold readings that weren't above normal, but he did find mold in the basement. Otherwise, there wouldn't have been any remediation. And he went through the process, he went through the test in the basement, and what he had to do to remediate it. Again, the reason, or you can infer, the reason why you didn't see the home inspection report is because it raised no concerns. That's why she then went through the deal. The fact that the defendant had 3 other deals, one being a cash deal, no contingency. You gotta wonder, why did he take it? Obviously, it wasn't as good as the $225,000 that Ms. Inez offered. So that argument that he had 3 deals just really doesn't weigh anywhere. He made representations. He made them orally to her. He made them in the residential disclosure form, and she relied on it. And she could rely on it because there was no indication that they were false at that time. But after moving in the house, all of a sudden, you got water in the backyard, no drainage problems. And look at those pictures, you know, they keep on talking about those pictures of the yard being, you know, pristine yard. I don't know. My yard doesn't have brown patches like that in it. That doesn't look like a yard that was perfectly taken care of, that doesn't have problems, where you have all those brown patches. When you go back to the jury room, all we ask is you consider all the evidence. And again, we believe when you review the history of the flooding in the backyard, from what the neighbor has said, from what she experienced upon, what Ms. Inez experienced upon moving in, from the percolating water in the basement floor in 2020, if that doesn't convince you this was a fraud, I don't believe there's anything in it. Thank you.
Thank you, Mr. Sternberg. All right, ladies and gentlemen, we're going to pick up where I left off with some concluding instructions. Yeah, I'm not sure why it's not going up. Oh, now I know why. All right. The court has given you the instructions on the law applicable to this case. I will now instruct you on how to conduct your deliberations and how to prepare your verdict. When you go to the jury room, your first function will be to select one of you to serve as foreperson. The person you select to preside over your deliberations does not have any greater power, nor does that person's vote have any more importance than others. That person serves the purpose of helping to conduct your deliberations in an orderly manner and to give you, each of you, the opportunity to express your opinion. One additional duty of the foreperson is to see to it that the verdict form is returned to the court after you have reached the verdict. Your initial conduct upon commencing deliberations is a matter of importance. It is not wise to express immediately determination to insist upon a certain verdict. Having so expressed yourself, your sense of pride may be aroused and you may hesitate to give up your position even if you are shown that it is wrong. Consult with one another in the jury room and deliberate with a view to reaching an agreement if you can do so without disturbing your individual judgment. Each of you must decide this case for yourself. You should do so, however, only after a discussion of the case with other jurors. Do not hesitate to change your opinion if convinced that it is wrong or if the discussion persuades you that you should. However, you should not surrender your considered opinion concerning the weight of the evidence to be congenial or to reach a verdict solely because of the opinion of other jurors. If you have a question during your deliberations, it should be discussed in the privacy of your jury room. It should not reflect the status of your deliberations. It should be reduced to writing, knowing the date and time of the question, so there will be no misunderstanding as to what you request, and it should be signed by the foreperson. It should then be delivered to the bailiff who will submit it to the court. Please be patient in waiting for a response, because the judge must consult with the lawyers for the parties before sending you his response. The court will then attempt to answer the question as best as possible. Please keep in mind, though, the court may not be able to answer all questions. Now, to conclude this case, at least 6 members of the jury, it is necessary that at least 6 members of the jury agree upon the verdicts. The members of the jury agreeing upon the verdicts must sign their names in ink to the forms of verdict to which they have agreed. The foreperson need not be among the 6 jurors who have agreed in order to reach a verdict. If 6 jurors cannot agree, you are instructed to report this to the courts. I will now read the verdict forms to you, give you some direction. The first page has the verdict form as the plaintiff's breach of contract claim. And you see it reads, we the jury, being duly impaled and sworn, find the issues in this case as to the claim of breach of contract against Nicholas F. Zevnik as follows. And if you find for the plaintiff, you're going to put a mark, a check mark, or an X in that first space there in front of the line that says for the plaintiff, Don Canez. And then it continues on saying in the amount of, and you see a blank line preceded by a $sign. That is the line that you'll place the total amounts of damages you're awarding Ms. Canez should you find in her favor. If you're finding in favor of the defendant on the breach of contract claim, then you'll put a mark on the blank space before where it reads for the defendant, Nicholas Zevnik. And then it reads, and we do so render our verdict on the concurrence of, and you'll put either the number 6, 7, or 8, depending on, you need at least 6 members to agree. It could obviously be 7 or 8, so however agree with the verdict, you put that number in that blank space, so it says concurrence of 6, 7, or 8 members of our said jury, that being 3/4 or more of our number. Each of us said jurors concurring in said verdict signs their name hereto this blank day of blank 2025, and you'll put the date it is and those blank lines that you have reached the verdict as to this breach of contract claim. You then see 8 lines. Those are the signature lines for each respective juror to place his or her signature. Ms. Drainer, juror number 1. We go along the back row to Mr. Sigel, who's juror number 4. Start back up in the front with Ms. Champel, who's juror number 5. And then we go to Ms. Sherwood, who is juror number 8. So make a mental note of what number you are. That will be the line that you'll be placing your signature on for these 3 verdicts. The second verdict form is the plaintiff's claim of fraudulent concealment and fraudulent misrepresentation. It reads, we the jury being duly impaneled and sworn find the issues in this case as to the claim of fraud, as to the claim of fraud against Nicholas Zevnik as follows. Again, if you find for the plaintiff, you put a mark in that first line and then a figure on the blank line preceded by the $sign in regards to the amount for that. If you find for the defendant, you place a mark on the blank space before it says for the defendant. It then reads the same. We do render our verdict on the concurrence of, again, 6, 7, or 8 members of our jury, that being 3/4 or more. You'll place the date that it is that you reach that decision, and each juror will sign their respective signature on the appropriate line. You then have some further directions here. It says if your verdict is in favor of the plaintiff and you award actual damages, You may also consider whether you will separately award punitive damages against Nicholas Zebnik. If your verdict is in favor of the defendant, or if you do not find actual damages, you will not consider punitive damages. And the next page has a form to report any punitive damages if you are instructed to address this issue. And it reads, in addition to the actual damages awarded, we, the jury, make an additional award to the plaintiff, Don Canez, against defendant Nicholas Zebnik in the amount of, and you see a blank line preceded by a $sign. That is where you'll put whatever figure, if any, that you award as punitive damages. And we decide that the attorney fees, and you'll see a blank line there preceded by an asterisk symbol, and it has below directions for that asterisk symbol, which reads, you insert either the word should or the two words should not be awarded against defendant Nicholas Zebnik. And you'll, again, place whichever finding you make in regards to attorney fees if you're addressing this issue in that blank space. It then reads the same in regards to rendering our verdict by the concurrence of, it depends, 6, 7, or 8 members of our jury. That's 3/4 or more. Place the date that you reach that decision, and then each juror places his or her signature on the respective or appropriate line. All right, let's finish up here. The court cannot embody all the law in any single part of these instructions. In considering one portion, you must consider it in the light of and in harmony with all the instructions. The court will place in your possession multiple copies of these instructions, the verdict form, as well as all the exhibits admitted into evidence during the trial. You will not be given anything else during your deliberations. During your deliberations, the court reporter will not be permitted to read back any portion of any of the testimony which you heard during the trial. Circumstances in the case may arouse sympathy for one party or the other. Sympathy is a common human emotion, and the law does not expect you to be free of such normal reactions. However, the law and your oath as jurors require you to disregard sympathy and not to permit it to influence your verdict. Thus, you must not be influenced by any consideration of sympathy or prejudice. It is your duty to weigh the evidence, to decide disputed questions of fact, to apply the instructions of law to your findings, and to render your verdict accordingly. Your duty as jurors is to arrive at a fair and just verdict. You have now been instructed by the court on all the law necessary for your deliberations. Whether or not certain instructions are applicable may depend upon the conclusions you reach on the facts by preponderance of the evidence. If you have the impression the court has indicated how any disputed fact should be decided, you must put aside such an impression. Nothing said in these instructions or in the earlier instructions, and nothing in the verdict form is meant to suggest or convey in any way or manner any intimation of a verdict I think you should find. That decision must be made by you based solely upon the facts presented to you in this courtroom. You're also warned not to discuss your verdict until it has been returned to the court, nor are you to discuss the status of your deliberations with anyone. This order must be strictly obeyed. After your verdict is returned and announced in open court, you may discuss the case with anyone, though you're not required to do so. That is a matter of your own free choice. When you have reached and signed a verdict, you will summon the bailiff, who will return you to the courtroom, at which time your verdict will then be announced. All right. That concludes our instructions. Mr. Sternberg, is there anything you wish to discuss any further on behalf of the plaintiff?
No, Your Honor.
Mr. Fogarty?
No, thank you, Your Honor.
All right, ladies and gentlemen, do you have any questions at this point before the court? I don't want to talk about any substantive issues, but procedure, what's going to happen, you're going to the jury room here. I suggest that you pick your foreperson, then if you want to take a break, you take a break, and then you begin your deliberations. In regards to any scheduling going forward, it's going to be up to you to decide what you want to do. We're not going to come in and say, oh, time for you to take a break, time to start deliberating, time to do whatever. You're going to decide that. It doesn't conclude today, you come back tomorrow, you decide if you want to take lunch. I mean, you'll decide from going forward what your schedule is going to be. The only thing I ask is that you do decide to take a break, don't just walk out. Let Buzz stand, let them come back there, tell them we're taking a break, and then that's fine. Had jury before, also we're just wandering the halls. We thought they were back to delivery, and we see jurors walking around, so we can't have that. The only other restriction is that you can only discuss this case when all 8 of you are present. So if you do take a break, if someone goes to the restroom, whatever the case may be, if all 8 of you are present, you can't continue discussing the case. All 8 of you must be present when you discuss this case. So at this point, I do want to thank each of you for the service that you have provided and you can continue to provide. And I want to express the appreciation of this court as well as the folks here in Lake County for the service you provided. By providing this service, you certainly have again contributed to what I believe is the best system of justice in this country, or in this world, actually. You will now retire to the jury room. The first thing you should do again is select your foreperson, then you'll begin your deliberations. Take a break if you want to. When you have reached the verdict, you'll sign the verdict in ink as I have advised you to. You'll then use the buzzer to tell Stan that you have a verdict. You will then be returned to the courtroom at that point, where your verdict will then be announced here in court. So at this point. Ladies and gentlemen, have you reached a verdict?
Yes, we have.
Can the foreperson please hand the verdict form to our bailiff? All right, the matter captioned Dawn Knez versus Nicholas Zebnik. Verdict form is the plaintiff's breach of contract claim. We, the jury, being duly impaled and sworn, find the issues in this case as to the claim of breach of contract against Nicholas Zebnik as follows. For the plaintiff, Dawn Knez, in the amount of $0. We do so render our verdict on the concurrence of 7 members of our jury, being 3/4 or more. Signed by 7 of the 8 jurors on May 1st of 2025. Verdict form is the plaintiff's claim of fraudulent concealment and fraudulent misrepresentation. We, the jury, being duly impaled and sworn, find the issues in this case as to the claim of fraud against Nicholas Zebnik as follows. For the defendant, Nicholas Zebnik, that is signed by all 8 jurors. The jurors did address punitive damage claim. We didn't need to do that, but it says 0 there. That was only supposed to be addressed if there was a... Anyway, that doesn't matter. Does either side wish to have the jurors polled? Mr. Sturger?
Yes, Your Honor.
Ladies and gentlemen, the bailiff is going to call you out by jury number and ask if this is or isn't your verdict. Respond. Okay.
Juror 1, is this your verdict? Juror 2, is this your verdict? Yes. Juror 3, is this your verdict?
Yes.
Juror 4, is this your verdict?
Yes.
Juror 5, is this your verdict?
Yes.
Juror 6, is this your verdict?
No.
Juror 7, is this your verdict?
Yes.
Juror 8, is this your verdict?
Yes.
Your Honor?
Well, that was the verdict for
You want the other one?
1. Then do verdict 2.
Okay.
This is for the fraud claim.
Juror 1, is this your verdict?
Yes.
Juror 2, is this your verdict?
Yes.
Juror 3, is this your verdict?
Yes.
Juror 4, is this your verdict?
Yes.
Juror 5, is this your verdict?
Yes.
Juror 6, is this your verdict?
Yes.
Juror 7, is this your verdict?
Yes.
Juror 8, is this your verdict?
Yes.
Thank you. All right, ladies and gentlemen, that concludes your service for this case.
Thank you.
I want to thank you very much for the service that you have provided. At this point, you are released from the restrictions that have been on you throughout the case. You can talk about the case with whomever you please, whatever you want, but you don't have to. But often the lawyers like talking with jurors after cases. I enjoy talking with jurors in cases. In fact, I'm going to pop back in there. I know it's late, but I'll chat with you just very, very briefly, answer any questions you have, and then send you on your way. So if you want to follow the jury room, I'll be in there in just 2 minutes, not even probably.
Mrs. Woman, I'd just like to apologize for our long your deliberations there. Thanks.
We're not, we'll never do that. We'll never ever do that. Why don't you follow the jury room?
All rise.
If you find by the greater weight of the evidence, plaintiff proved their claim for breach of contract, then you must further decide whether the defendant's breach caused plaintiff to suffer any damages, and if so, in what amount. I then got a question, 2 questions at 4:38. The first was, what do we do if we cannot get 6 jurors to agree? After meeting with counsel, we responded by saying you need to keep deliberating. That next question took a little more time. The question was, does the as-is release seller from any or all items disclosed or not disclosed in the agreement? The court responded after consulting with counsel saying it depends. Since there was an inspection, the as-is clause will release the seller from liability for any undisclosed conditions if during the inspection the undisclosed conditions would be observable by and discoverable to a reasonable person. And that was the response that was given. Mr. Sturber, is there anything else you care to address for the record?
No, Your Honor.
Mr. Fogarty.
Nothing, Your Honor.
Thank you.